for repairing on urgent basis. I have supplied the photographs with your lordship's brief. The situation with the before the landed court bill also, the situation of the dwelling house of mine. Those applications have not been taken care of. Even that has been not reflected in the order sheet. I have procured the SIA number. Your lordship knows, my lord, as per R13 rule, form R13, that is to be recorded under SIA. SIA has been recorded. My application has been recorded in the court below, but nothing reflecting in the order sheet. I am out of the property because of not repairing in the monsoon season, my lord. Kindly see the visualize, my lord, the photographs from page 42 onward, my lord. On 9/6/2026, I filed the, my lord, application. After that, the several orders have been passed. Not even any date given for hearing of my applications. But my lord, that will also take some. Then my lord, kindly. My lord, there is no difficulty. My lord, then my lord, two things, my lord, may I submit with subject to approval by lords. My lord, there 151 has been admitted by without my hearing me, my lord, and police protection have been given to. My lord, kindly have a look. No, my lord, kindly have a look at, my lord, order dated 20th March. No. And my lord, in the meantime, my lord, may I get that order, my lord, that for starting of the repairing work, my lord, only. My lord, that has not been, my lord, kindly see the for repairing also. My lord, then my lord, my lord, no, my lord. No, kindly say time bound manner, my lord, with a time bound manner, so that my two applications can be taken up, my lord.
No, 4 and 5 are revisions.
No, item number 3, I appear for the petitioner, my lord.
I may appear, my lord, if your lordship, my lord, gives a copy in the next day, any.
No, my lord. Today is a demolition fix, my lord. Today at 11:30, my lord, they are going to carry out the
Very
demolition.
good, my lord. Let him, my lord, proceed. That well,
Because today at 11:30, there is demolition, my lord. Lordship, this is an appeal, my lord, challenging an order, my lord, passed by, my lord, the Kolkata Municipal Building Tribunal, my lord. My lord, before that, my lord, may I just take your lordship to page number 38 of my application. 38 of my application. Well, is an order dated, my lord, 26th of February, my lord, 2024, passed by my lord Justice Amrita Sinha. Now, my lord, there, my lord, one person, my lord, filed a writ petition, my lord, alleging illegal construction. My her ladyship was pleased to consider the application and was pleased to direct, my lord. The direction, my lord, operative direction is at page 39, my lord, second paragraph. The writ petition is accordingly disposed of by directing the respondent number 6, being the executive engineer civil, Kolkata Municipal Corporation, to my lord. Now, my lord, they were directed to give opportunity of hearing to all concerned parties. Now, my lord, we are the tenants, my lord, of that building since 2023. Now, my lord, 2023 we had been come in possession, my lord. We are not given an opportunity of hearing. Thereafter, my lord, after that, my lord, the demolition of 401 order was passed on 19th of April 2024, my lord. Authorities, my lord, proceeded to carry out demolition in the year 2026, my lord. From that, we came to know that there is a demolition proceeding against us. We came before the High Court. Our writ petition before the single bench was dismissed. We went up in the appeal. Appeal court, my lord, granted us directed the corporation not to proceed for 1 month. In the meantime, if we go before the building tribunal, that will be taken care of. My lord, because that application will. We went before the building tribunal. We filed an appeal under section 400, subsection 3, my lord. Now, my lord, our prayer for stay was refused by, my lord, the learned tribunal on the ground, my lord, because, my lord, the division bench said that whether we could file an appeal, because that point was kept open. Now, my lord, building tribunal observed that, my lord, there are major deviation, so stay could not be granted. However, keeping the appeal pending. And appeal has been kept pending. My lord, in the meantime, if the demolition is being carried out, my lord,
page number 9.
my lord, the last page of the certified copy, my lord,
Page 80.
it is, my lord, page, not page number. Ordered, my lord, that the application for stay filed by the appellant is considered and rejected, no others to cost to date. My lord, the appeal is being fixed on, my lord, 8th of August, my lord. The date in the appeal, my lord, appeal has been kept pending. Appeal has not been disposed of. My lord, that's, hmm. My lord, that, my lord, order has been passed, my lord, subject to correction. It has been passed in 2024, my lord. Now, my lord, we are in 2026, my lord. If the on 5th of August, my lord, my lord, 8th of, because, my lord, the appeal has been kept pending. In the meantime, my lord, the subject property, my lord, if the subject, my lord, the subject property is lost, my lord, then, today, my lord, demolition will be carried on. My lord, thereafter, my lord, the appeal would become infructuous, my lord. Because, my lord, if your lordship kindly sees the impugned order, my lord, in the appeal, my lord. No, impugned of the appeal, my lord, page 53, my lord. 53, my lord. My lord, we were never party to this proceeding, my lord. We were never not party to this proceeding. My lord, that was found in the year 2024, my lord. 19th of April, my lord. My lord, no, my lord. The appeal is fixed on, my lord, 8th of August, my lord. Let the appeal be heard, my lord. My lord, till that time, my lord, let them not proceed. Because, my lord, today, if the demolition is being carried on, my lord, where shall we go, my lord? Because, my lord, Lordship would kindly appreciate, my lord, the corporation has sat tight for 2 years, my lord. corporation sat tight for 2 years, my lord. 2 years there has been no proceedings, my lord. After 2 years, they suddenly wake up, my lord, and proceed to demolish, my lord.
With this kind of an observation, I cannot.
My lord, that,
You will be free
well,
to
well, that
you will
observe-
be free to approach the Kolkata Municipal Corporation authorities and buy time if you can. You
No,
cannot
well,
be blessed by a judicial order in this.
no, my lord, this order, if this order is not, my lord, state, my lord, the corporation will
I will
my
not
lord,
stay the order, sir. I have made it clear. With this kind of finding, who will stay? With this kind of finding that it is unsafe for the occupants of building, I will impose my intelligence here.
my lord,
There is a
because,
technical
my
finding
lord,
by an officer.
because, my lord, the petitioners are the occupants, my lord. Now,
It
my lord,
doesn't
they have been
matter. If you
deciding-
are the occupant, you are the person who is more at stake, whose life is at stake, whose
My-
property is at
My
stake.
lord, for 8 days, my lord, it is fixed on, my lord, 8th
Even
of
one
August.
day, 1 minute is important, sir. If this kind of an observation is there made by an authority who is an expert, the building tribunal has refused to stay. What is there
No,
for
my lord,
me
that,
to
these
superimpose
my lord,
myself on this?
these observations, my lord, we can
Sir, you
controvert.
can go on arguing. I am not
No, my lord,
satisfied.
these
I will
observations
not stay.
we can controvert at the time of hearing of the appeal. But your lordship would kindly see if the building is demolished today, my lord.
Don't find any case, sir. The building is demolished, it's demolished. It is something which should be demolished. If this is the condition of the building, that it is unsafe for the occupants of the building.
But we have to.
What factual material do you have to say that it is not unsafe? What factual material do you have to
We
say?
can, my lord, controvert this finding because these are, my lord, findings in the CR, my lord, which we did not have, my lord, because we did not participate in the initial
Neither we are
proceeding
not
as
there.
well, my lord. 401 proceeding, my lord,
You
we
will
did
be
not.
free to approach the municipal authorities to buy time. If they feel that they can grant you time, you can take time. I will not bless you with an order saying that this demolition should be stayed despite a finding of two authorities concurrently that the building is unsafe for the occupants of the building. I will not.
No, my lord, Lanet Tribunal proceeds on the findings in the order, my lord.
Correct. Correct. Because you have not been able to dislodge it prima facie.
No, my lord, because, my lord, the documents were never before us, my lord.
Division bench told to
This
plain stay.
revisional application, a sales and
I'm sorry, my lord, in the midst of the judgment, my lord. Kindly see, my lord. Page 44, para 5. What was the observation made? Mr. Ghosh also submits that the third, fourth, and fifth floor are palpably illegal and no sanction has been granted by the corporation for construction of those floors. If the tenants are residing in those floors, they do not have a right to seek judgment.
Mr. Bhattacharya, I can only grant you leave to approach them. Nothing more. I cannot.
Today, I have.
Today you approach them.
No,
Approach them
today is
today.
the date for demolition.
You approach them today.
Well, kindly
Can't be
see
helped.
at the next paragraph. We are not inclined to express anything on the issues raised by Mr.
Yes,
Ghosh
because
in
that issue was not raised. That issue was not
Definitely,
before the
definitely.
learned
That was to be
court,
decided by
before
the
honorable
tribunal.
division bench.
That
That issue has been prima facie settled by the tribunal against you. There is nothing on record to show that this is wrong. Show me something that this is
we
wrong.
were not given any opportunity of hearing.
Today you show me, before the tribunal you could have shown that that you have a prima facie case that the building is not
We were
superimposed.
not given any opportunity of hearing with the
Before the
tribunal.
tribunal you were there.
Before the tribunal.
So
But
before the
we
tribunal
did not
only you
have
are-
these reports. Kindly appreciate. All are mirrored one-sided.
Now tomorrow, if after the order of stay the building collapses, what will happen? Will you take responsibility for that? Will you take responsibility for the collapsing of the building? Merely because it has sustained for 2 years, does it mean that we should allow it to sustain for another 1 month, risking the lives of everybody who is there?
I understand that.
What kind of order?
Kindly appreciate, Milord. I was never given any opportunity of hearing.
That is very good. But your opportunity of hearing will not be important than your life itself. Do you take the risk of you run the risk of your life being trampled by the building collapsing, and you say that you have not been given opportunity of hearing?
Kindly appreciate, Milord. It was, Milord.
That is why the best you can do is you can approach the municipal authorities. If they feel that yes, this is something which is extendable, they can do it.
But they have
by an
because
order of
today is
court.
the date fixed for demolition. Notice
That is all. Then that's all.
Where will I
that's
go?
all.
Milord, kindly appreciate. I have went to the appropriate.
Mr. Ghosh was here. Sir, Mr. Ghosh, let him come then. It can't be ex parte. He was there. He left because I indicated my mind. You serve him and come back then.
At 2 o'clock.
Come back tomorrow.
At 2 o'clock, Milord. Today is the date, Milord.
Come at 2 o'clock.
At 2 o'clock. Serve karo.
2 p.m. Next.
Wait, please, Lord. Malod's only one request, Malod's, before learned senior start. I beg to appear
for the respondent number 1, Milord, I am being led by Mr. Sundaram is in virtual mode.
Yes, Malod. So let Mr. Mukherjee start, Malod. We are here, Malod.
Now, Milord, may I just indicate very briefly, Milord, what the matter is about? Milord, the opposite party number 1, Milord, had filed a suit, Milord, against Milord, all Milord, the occupants of Milord, Woodland Syndicate. Milord, there are 40 flats. Milord, the suit was against all the occupants of the set of these flats. And Milord, an ex parte order, Milord, was obtained, Milord, on 30th of April 2026. Milord, I just want to show your lordship that order. Milord, it's at Milord, page 126, Milord. Milord, the plaintiff, Milord, is the trustee. Milord, and Milord, the persons, Milord, in occupation, Milord, have, Milord, the beneficial interest. There's a declaration of trust to that effect. In fact, Milord, the property had been purchased, Milord, by funds of, Milord, these companies, Milord, blue chip companies who were then in Calcutta. Milord, these flats were purchased, and Milord, it was held in the name of the trustee beneficial interest of, Milord, the flats and outhouses. Milord, belonged, Milord, to Milord, these various companies. Now, Milord, he files a suit, Milord, and Milord obtains this order, which your lordship will find, Milord, at page, Milord, 26, it starts, 126, and kindly come to, Milord, page 130, Milord, where, Milord, the, Milord, finding starts. Then kindly come to, I'm not troubling your lordship too much with it, 133. My lord, it says to show prima facie case, the plaintiff has submitted documents listed below. My lord, kindly mark Annexure B. And my lord, kindly mark, my lord, the last of, my lord, the 9 supplemental declaration of trust at page 134, Annexure E. Lordship has that, my lord? At page 134, first document. Kindly just mark these, my lord. And then, my lord, kindly
Annexure F.
come.
Page 134, Annexure F.
No, E, my lord.
E.
My lord, all are, my lord, relevant, but my lord, kindly, for the time being, my lord, I just need to, my lord, draw your lordship's attention to. Then kindly come to Annexure BB. My lord, this is certified copy of deed of conveyance dated so-and-so executed by 17 in favor of 13 in respect of flat number 27. My lord, I am 13, my lord, ITC Limited. Now, my lord, kindly turn over to the next volume, my lord. Now, my lord, kindly come to, my lord, page 137. On careful perusal, I find that the plaintiff's title as registered owner, 137, my lord, third line. On careful perusal, I find that the plaintiff's title as registered owner and trustee of suit property is established from deed of conveyance dated 19th October 59 and declaration of trust dated 16th August 1961, both being matters of public record at the competent register, further confirmed by the KMC property tax records bearing assessee standing in plaintiff's name. So, my lord, trustee, legal title, my lord, with him. My lord, beneficial title. I'll show, my lord, the declaration of trust. Then, my lord, kindly come to, my lord, page, my lord, 138. My lord, kindly take second, my lord, sentence of the new paragraph, that 7th line, my lord. This accordingly not a transaction in which only 15 as transferring party and 2 as receiving party are implicated. The members of defend number 1, whether recorded as syndicate members under 9 supplemental D or presently in occupation of any flat through or under any such member, collectively sanctioned, facilitated and gave effect to impugn transfer with full knowledge that any dealing with trust property could only be effected with participation of plaintiffs as trustee. By doing so, members of defend number 1 have collectively arrogated to themselves the authority of plaintiff as trustee, depriving the plaintiff of its role in and control over the trust property and facilitated the creation of clout upon the plaintiff's title as sole legal owner and trustee. So, my lord, the entire argument proceeds on the basis that, my lord, the plaintiff's title, my lord, as my lord, legal owner, being, my lord, a trustee, my lord, is being interfered. Then, my lord, kindly come to, my lord, the order, my lord, page ordering portion, similar finding with regard to my transaction, kindly come to page 139. The prima facie case is therefore clearly established from documents themselves and more particularly from defendants' own admissions in their own correspondence and in their own registered instruments. The balance of convenience and inconvenience is entirely with plaintiff. The plaintiff is the sole legal owner and trustee of suit property and has been wrongfully excluded from access to administration of trust property. Granting injunction merely preserves the status quo and does not require the defendants to do anything beyond refraining from further unauthorized dealings in property, which admittedly on their own concession belongs to plaintiff's trustee. No injustice is done to a party by restraining it from doing that which it has no right to do. Refusing injunction, on the other hand, will allow defendants to continue executing void instruments, creating further third-party rights and dealing with trust property as if they were. Then any further dealing, encumbrance or creation of third-party interest in respect of Schedule B flats will give rise to complications incapable of being undone by a money decree. Location at Alipur being unique and irreplaceable trust property is sustained and alone. The suit property consists of 40 residential flats of substantial value in a prime coordinated pattern of unauthorized dealings spanning at least 9 years as evidenced by 2017 deed and escalating as evidenced by 2024 and 2025 deed has been placed on record. Each further void document executed in respect of trust property creates a flesh crowd on title and introduces further third-party rights which will require separate adjudication. The harm occasioned by continued progressive encumbrance of an immovable trust estate is by its very nature incapable of adequate compensation in money. Plaintiff will suffer irreparable. I'm also satisfied that there is sufficient cause for the plaintiff to move ex parte. The board resolution of defendant number 15 dated 27 January exhibited to and forming part of registered deed of conveyance dated has already authorized sale of flat 40. No further corporate authorization is required for defendant number 15 to proceed. Same internal procedure by which transfer of flat 29 was effected, namely by issue of circulation of minute by one and execution of supplementary agreement by so-and-so remains available to be invoked again, and there is every reason to apprehend defendant number 1 will issue a further so-and-so and facilitate, etc. Further, the agreement for sale between 2 and 15 contain a specific confidentiality clause to prevent plaintiff from learning of flat 29 transaction, etc., etc. Doctrine of can seek as held by Supreme Court. The doctrine of lis pendens under 52 may not always be sufficient to protect the plaintiff's interest, and a court injunction is the only effective protection. So and so, this is clear by title is, etc. This, my lord, considering the facts, my lord, order is passed. My lord, complete, my lord, injunction with regard to, my lord, the 40 flats, and my lord, Schedule A, my lord, is, my lord, the common areas, my lord, in, my lord, this building. And, my lord, cannot deal, my lord, with, my lord, the statutory authorities. My lord, flat owners had been paying, my lord, the, my lord, duties, my lord, the municipal corporation, my lord, taxes and rates and taxes. My lord, even that, my lord, trustees never done anything. Trustees been sitting, my lord, from 2005. And 1 and 2 further.
Lord, I'm sorry, I have to interrupt only to say one thing. It's a bit unfair, my lords, of my learned friend, and I'm going to say it's not maintainable. This order has not been appealed. This order is not subject matter of the appeal. They filed a 39-4. Just one, not appeal. I'm saying a revision. I'm saying a revision. Please, Mr. Mukherjee, let me state my objection, and then you can please deal with it. My objection, my lord, is this is the order of ad interim injunction. This order, no revision has been filed, no appeal has been filed, nothing has been filed. Thereafter, they filed a 39-4. This order was extended, and 39-4 is slated today for at 3 o'clock in the afternoon. Now, my lords, at this juncture, my learned friend is challenging really only the extension order, not this order. The extension order is extending pending his 39-4, which is also still pending. Their whole case was that there is an agreement, and under that agreement, they are entitled. I filed an application for directions to produce the agreement, and the court said, yes, produce that agreement because your defense is based on the agreement. Their second revision, item 5, is against that order of directions directing them to produce the agreement. A party who relies on an agreement is directed to produce the agreement. He can say, I will not produce it, adverse inference can be drawn. But the fact is the court has given him the opportunity and said, produce it. Now that's the second revision, item 5.
Let Mr. Mukherjee complete his submissions. I'll come back.
My lord, but I want to place this preliminary objection because he's read this order in extenso. This order is not the order against which the revision is filed, nor is it the order against which any appeal has been filed. I wanted to bring that to my lord's notice.
Yes.
Now, my lord, this was the ex parte order, my lord, which had been, my lord, passed. Then, my lord, we appeared, my lord, in the matter. My lord, we filed an affidavit saying, my lord, that the order should not be extended at all. Now, my lord, on what basis? My lord, we relied on the document they rely on, my lord, which is the Declaration of Trust. And, my lord, we said, my lord, we relied on the provisions of the Trust Act because, my lord, a beneficiary has, my lord, an indefeasible right to transfer his beneficial interest. My lord, kindly have a look at the deed of Declaration of Trust. And, my lord, and the extension is not a one-line extension, extended. Extension is 58 does not apply. My lord, that's what I want to show your lordship, which I have come up against, my lord, by way of appeal. In the appeal, my lord, no, my lord, stay was granted. We've come up, my lord, before your lordship. And the, my lord, suit with 40 flats has been valued at 3,000 rupees. My lord, to ensure that the appellate court is not the high court. Now, my lord, kindly have a look at, my lord, the deed of declaration. At, my lord, page 11224, volume 9, my lord, page, my lord, 1124. I just checked this.
Yes.
My lord, kindly have a look, my lord, at page 1124.
Yes.
Kindly see, my lord. This declaration of trust made the 16th of August 1961 between Dalhousie Holdings, who's the plaintiff, whose registered office is at so-and-so, shall include the trustee or trustees for the time being under these presents of the one part. Now kindly note the next. And several companies whose names are set out in the first schedule hereto, hereinafter called the syndicate members. Then, my lord, kindly see next. Which expression shall include the syndicate members for the time being of the syndicate, hereinafter referred to as the other part. Now, this is a declaration of trust which is binding on the plaintiff, who were, my lord, and my lord, being held for the benefit of the syndicate members on that date and all who become syndicate members thereafter. Now, my lord, kindly come to, my lord, page 1128, clause 1.
Yes.
The trustees hereby declare that each syndicate member is the beneficial owner of the flat or flats allotted to such member as set forth in the third schedule hereto, and outhouses allocated to such member, so that each syndicate member, kindly mark the words, shall have exclusive possession of the flat or flats and outhouses so allocated, and shall be entitled to exercise all the rights incident to such ownership, subject always to such restrictions as may be imposed by whom? Not trustee, by the syndicate members in terms of the proposed syndicate agreement, without any hindrance by or interference from other syndicate members. So, my lord, beneficial interest in flat, outhouses, which is, my lord, exclusive possession and entitled to exercise all rights incident to such ownership. This is what I have in the flat and outhouses. And then, my lord, 2, and he's bound by it. He's the trustee. My lord, I'll show his praise in the plaint. He's acting against the trust. Now, my lord, kindly see 2. The trustees hereby declare that this said piece or parcel of land and entrance, common passages, staircases, lift shaft, and lifts of the said building, hereinafter collectively called the Servian property, will be held by the trustees in trust for the syndicate members absolutely in the following shares. Then, my lord, kindly have a look at 3. Upon dissolution of the syndicate, trustees shall deal with the Servian property in such manner as the syndicate members shall direct, and shall in relation to Servian property be bound to comply with directions of syndicate. So, my lord, 1 is beneficial interest. They can do anything. They don't have to refer to the trustee. Another, my lord, is the common area, which, my lord, trustee will, my lord, act as per directions of the syndicate members. Then, my lord, now kindly see, my lord, at page 112, my lord, please. Now, my lord, kindly come to, my lord, prayers, my lord, in the plaint. Kindly have a look at the prayers in the plaint. My lord, volume 3, page 382.
Fundamentally so wrong. Right, asking for declaration. Practice. बोलो
हम प्लेट का रखा कोई प्लेट
Where we proceeding the
Yes.
My lord, kindly have a look at prayer. My lord, C. Deed of decree for declaration that the plaintiff has been the sole legal owner and trustee of Schedule A property and legal title thereto vests exclusively in the plaintiff and his capacity. No problem. Nobody is disturbing it. Decree for declaration that a registered supplementary declaration of trust with participation of plaintiff as trustee is and has always been the only lawful mode of effecting any change in trust structure. This is contrary to the my lord, deed of declaration that beneficial interest belongs exclusively my lord, to my lord, the syndicate members. They can do everything with their beneficial interest. Trustee has no say. There is no clog on title created by the declaration of trust as far as syndicate members are concerned. This is completely contrary, my lord, to the deed of declaration. Now, my lord, kindly have a look at prayer E. My lord, trustee trying to grab the property. Kindly have a look. A decree for declaration that defend number 4 through 22, these are all the companies, have by their conduct as set out in the plain, abandoned, relinquished, extinguished all beneficial interests previously held by them in their respective allocated flats described in Schedule B, and that such beneficial interest has consequently reverted to and is now held by the plaintiff in it. This is a trustee saying this. Now kindly have a look at
14.
kindly have a look at Miller section 14 first of the Trust Act, and Miller I'll show section 58.
The Trust Act unenacted.
Miller, we have a copy, Miller. Kindly take Miller a copy.
Fundamentally wrong.
Miller, the suit on the face of it. Follow him, then you'll know what to show. Miller, section 14, kindly have a look. The trustee must, I'm sorry, your lordship has that. The trustee must not for himself or another set up or aid any title to the trust property adverse to the interest of the beneficiary. My lord, with the greatest of respect, kindly have a look at his suit.
He cannot.
He cannot do it. Now have a look at 58. Section 58, my lord. Now kindly note this. The beneficiary has a right as against the trustee and all persons claiming under him with notice of the trust to inspect and take copies of the instrument of trust. Sorry, Miller. That's 57. 58, Miller. The beneficiary, if competent to contract, may transfer his interest, but subject to the law for the time being in force as to the circumstances and extent in and to which he may dispose of such interest. So, my lord, immovable property, beneficial interest, conveyance. My lord, shares, my lord, movables, my lord, accordingly. It's the mode, my lord, of transfer, my lord, it has to be subject to that. Then, provided that when property is transferred or bequeathed for the benefit, this is not applicable, my lord, of, my lord, a married woman. So, my lord, I have an absolute right to transfer. Deed of declaration says, my lord, I have the beneficial interest and I have the exclusive right to, my lord, possession and deal with it, my lord, as if I'm the owner. Trustee's role, my lord, is not envisaged at all. Cannot be. And over and above that, he cannot set up anything, my lord, which is contrary or adverse to my lord, interest, my lord, in the property. Now, kindly have a look at, my lord, the extension order.
Order 13 and before order 13.
My lord,
The Supreme Court has acted.
now, my lord, kindly come to. Yes. Now, my lord, kindly come to. My lord, volume 2. My lord. My lord, page, my lord, 150. This is, my lord, the extension order. My lord, kindly take, my lord, our submissions, my lord, 13s at page 151. My lord, defend number 13. Kindly, my lord, I'm just troubling you. Defend number 13 has further stated that plaintiff does not have any right to sue or locus standi to institute the suit. The plaintiff cannot challenge any transfer of beneficial interest by members of the syndicate. Plaintiff is also not a member of the syndicate, and plaintiff has not suffered any legal injury. Defend number 13 and other defendants have argued that they were fully entitled to transfer their beneficial interest in the suit flats under a syndicate agreement. Learned senior advocate has stated that right to transfer beneficial interest is recognized by Indian Trust Act and submitted that impugned conveyance is accordingly valid in law. 13 and other defendants have raised the point that the suit is grossly undervalued at 60,200, whereas plaintiff has prayed for recovery of possession of 40 flats, each valued at approximately 8 crores, making the connect valuation at least 320 crores. My lord, there are 40 flats, my lord, in this syndicate, my lord, in Alipur. My lord, suit is filed at 60,000. Because, my lord, till 1,50,000, my lord, the appeal is before the district judge. Above 1,50,000, my lord, High Court. Now, my lord, kindly see 152. My lord, third paragraph. Argument over the matter of Trust Act. Your lordship has that? Learned senior advocate for defend number 13 has submitted that section 58 of Trust Act expressly confers upon a beneficiary who is competent to contract the right to transfer his beneficial interest, and that this right was validly exercised by the executed, the registered act. Trustee is bound to obey the respective syndicate members when they. He further submitted that under 11 of the act, author of the trust as so and so, etc. Then, my lord, the other submissions, then submissions of the plaintiff. My lord, kindly come to, my lord, the submission dealing with, my lord, page, my lord, 155. On the Trust Act on the Trust Act argument, the learned advocate for the plaintiff has submitted that argument under section 58 cannot be read in isolation of other provisions of the Indian Trust Act. Section 3, 39, 56, 58, and 69 must be read conjointly, and when so read, they establish the indispensable necessity of the plaintiff as trustee in any transaction purporting to deal with trust property. Then, my lord, what is a beneficial owner? Section 3. My lord, 56 deals with, my lord, not transfer of beneficial interest, but legal title. Then, my lord, all this is considered. Now, kindly come to, my lord, findings. My lord, I'll trouble your lordship only with, my lord, 1. My lord, 160. Although 13 and other defendants commenced their arguments on points of valuation subsequently and grounds referred to, as this court has already allowed time to plaintiff to file objections, this court is not inclined to deal with grounds of Order 39, Rule 4 at this stage. However, as both parties have addressed submissions on Indian Trust Act, this court is constrained to briefly discuss. Then, my lord, comes, my lord, the discussion. Kindly come straight away to section 58 at 162. Section 58 permits transfer only of beneficial interest as defined in Section 3, a personal right against the trustee, not an estate and immovable property. The impugned deeds purport to convey freehold ownership, which no syndicate member ever held. Section 58 does not authorize transfer of what the transferor does not have. Section 58 is expressly subject to the law for the time being enforced as to circumstances and extent extent of disposal, beneficial interest being only a personal right against the trustee as owner under section 3 is not an estate. Impugned deeds accordingly go beyond the scope of 58 and cannot derive validity therefrom. Then section 58 read with 69 means transferee acquires no greater right than transferor. Transferee can only receive only a limited personal conditional beneficial interest, not freehold ownership of the deeds purports to convey. My lord, nobody is claiming that. He's still, my lord, the owner as trustee. The beneficial interest, my lord, which has been transferred. And this is, my lord, 58. And kindly now have a look at section 3. How can he now, my lord, claim back the property and get an injunction? He himself is accepting that it operates against the trustee. Kindly have a look at section 3, my lord. My lord, interpretation clause. Lordship has that. Trust is an obligation annexed to ownership of property and arising out of a confidence reposed in and accepted by the owner, or declared and accepted by him for the benefit of another or of another and the owner. Then, my lord, author, etc. Kindly come to, my lord, the person, my lord, the second line, the person who accepts the confidence is called the trustee. The person for whose benefit the confidence is accepted is called the beneficiary. The subject matter of the trust is called trust property or trust money. Now, kindly note this. The beneficial interest or interest of the beneficiary is his right against the trustee as owner of the trust property. Now, my lord, if that is being accepted, and that's what he has said here, it's a personal right against the trustee. Now, my lord, kindly come to 165. My lord, the new paragraph starting having discussed 13, 3, 58, 11 and 39 and also considered the submissions made relating to 56, this court finds that if these provisions read conjointly, prima facie establish the indispensable necessity of plaintiff as trustee in any transaction purporting to deal with trust property. My lord, it's dealing with the beneficial interest in trust property, not the trust property itself. Then, my lord, and that the impugned deeds of conveyance go far beyond what any provision of the Act authorizes. Defendant 13 has neither denied nor disputed the admission in recital 7 of its own registered deed dated 9 June, which records that the only recognized mode of recording transfers, my lord, kindly mark this word, recording transfers of beneficial interest was through registered supplemental so-and-so. Defendant 13 is not in a position to advance a case in these proceedings directly contrary to the solemn admission in his own registered. Now, kindly have a look at this document. Give me 2007.
748.
I will kindly come to page 748. Volume 6, man. I will kindly come to 755. What is being transferred? Now this deed witnesseth as follows. In pursuance of acceptance of offer by the transferee and in consideration of payment of the said sum of 4 crore 60 lakhs, so and so, the receipt whereof the transferor hereby as well by memo admits so and so, acquit release forever discharge the transferee and the said flat 27 hereby conveyed, the transferor doth hereby transfer, convey, relinquish, assign and assure unto the transferee all that the said beneficial interest as a beneficiary under number so and so. So what is being transferred is beneficial interest, not the trust property itself. And, my lord, the admission which they refer to, My lord, is, my lord, 753, recital 7. And I'll show the last one. Thereafter, several supplementary agreements were executed between syndicate members, and supplemental declarations of trust were executed and registered by the trustees to do what? Not to effect the transfer, but to record the transfers of beneficial interest by beneficiaries, that is the syndicate member. It's to record, and I'll show, my lord, one of them. My lord, kindly take, my lord, the 9th supplemental deed. My lord, volume 5, page 604.
7 February.
My lord, this is, my lord, dated, my lord, I think
10 February 2005.
10th February.
Seven.
No, it's not even 7. It's 10th February.
10th.
10th February 2005, my lord. Handwritten, my lord, in words, my lord, which is why
604.
604. Supplemental declaration of trust. Now, my lord, kindly come to clause 4, my lord. My lord, two clauses I'll show, clause 4 and clause 7, because the second, my lord, limb of the argument I will make is with relation to production.
Clause 4.
Now, kindly see clause 4. By an agreement dated 6th October 1961, made between the trustees of the one part and several companies therein described as syndicate members, and hereinafter called the syndicate members of the other part, hereinafter called principal agreement, the then syndicate members constituted a syndicate named as Woodland Syndicate, which was deemed to have been constituted on and from 7th day of April, so and so 59, with the object of inter alia providing purchase money for purchase of land bearing so and so, more particularly described in first schedule and also in the second schedule, of one or more to construct one or more buildings and for management, administration, etc. Now, Miller, kindly come to 7. 6 and 7, my lord. Now, my lord, I have shown your lordship, my lord, the declaration of trust by the owner, my lord, which says syndicate members for the time being. It's not only those who are mentioned there who become from time to time. Now, kindly have a look at 6. Since completion of principal deed and supplemental deed, several supplemental declarations have been executed in order to do what? Not to transfer. In order to record therein changes from time to time in the names of beneficiaries and the shares of their respective beneficial interest in trust property. In order to update the principal deed and said supplemental deed declarations of trust to record the current names of beneficiaries and respective, the syndicate have agreed to modify the principal deed as varied by so and so. This is for the protection of syndicate members, so that trustee can't turn around. But, my lord, as far as syndicate members are concerned, amongst themselves, they are free, my lord, to deal with, my lord, the, my lord, properties. And, my lord, no, my lord, objection can be taken. Now, my lord, what happens? My lord, lordship seen the reasoning, my lord, in, my lord, the order.
150
Kunta?
the first June decade order.
Ah. Now, my lord, kindly take, my lord, the order once. My lord, the,
We are at 165,
my lord, we were at page 165.
167.
My lord, after, my lord, recital 7, kindly see. Having discussed so-and-so, that is so-and-so, has neither denied nor disputed the admission in recital 7. Now, my lord, with greatest of respect, I've shown your lordship recital 7 to record the transfer of beneficial interest. It's not to convey. Records that the only recognized mode of recording transfers was through registered supplemental. Defendant number 13 is not in a position to advance a case directly contrary. The court further notes that impugned date of conveyance, this doesn't concern me, my lord, etc. Then, my lord, all findings herein are tentative, shall not bind the court. Court accordingly finds the Trust Act argument advanced by defendant number 13 does not constitute a valid ground to refuse extension of interim order and does not disturb the prima facie case recorded in the order. And I say, my lord, that this is completely, my lord, contrary to statute. completely contrary to statute. This, my lord, exercise, my lord, of discretion. Now I go up on appeal. Kindly see, my lord, what. Yes, and my lord, page 167. My lord, there was, my lord, also an order 11 rule 14 file. My lord, I had relied on the syndicate membership, my lord, members agreement of October 1961. My lord, I had a tattered typed copy. My lord, I was told you produce the original. My lord, number one. Number two, my lord, it was filed while the hearing was on. We asked for time to file an affidavit, not given. And my lord, whatever flats I'm in possession of, I, the defendant, have to produce, my lord, all the documents. Now, my lord, kindly have a look at, my lord, that's the separate revision which I'll address your lordship straight after I conclude this. Now, my lord, kindly come to, my lord, 166. Yes, now, my lord, kindly have a look at. Yes. My lord, what they have said in effect, my lord, is an order in terrorem that if I don't produce these, don't hear their order 39 rule 4. That's what the finding is. Kindly, my lord, come to, my lord, page 166. My lord, on the application under order 11 rule 14, this court has perused the typed copy of the alleged syndicate agreement annexed in annexure C to the vacation application. Now pausing here. My lord, 6th October 1961 is the agreement, syndicate agreement, also referred to in recital 4 of the 9th supplementary deed. Plaintiff has relied on it, but he doesn't have to produce anything. Now, my lord, this court is satisfied that the document is a typed copy bearing only SD notations in place of original sign. Now, my lord, I pause here. My lord, if it's a typed copy, my lord, it's nobody is saying it's a forged type copy. Now, my lord, the defend number 13 has though emphasized and relied upon the document as the principal injunction application and document. This court strongly believes that for satisfaction of the court, the original document has to be produced for determining the crucial disputes involved in the suit, injunction application, and application under Order 39 Rule 4 CPC. It is true that defendant number 13 has not filed any formal objection against application under Order 11 Rule 14 filed by the plaintiff. But as Order 11 Rule 14 is an enabling and discretionary provision, kindly mark the words here, to be exercised wherever the interests of justice demand and applies with particular force, whereas in the present case, the document sought is an unregistered private document of which no certified copy is available from any public registration authority. And defendants, doesn't say I am, defendants are the only custodian. The original is indispensable for the proper adjudication of the matter. This court is satisfied that production of the original alleged syndicate agreement and a full disclosure of the flats presently held by 13 are necessary before this court, which proceeds to decide the vacation application. Hence, this court is disposing of the application and directing defend number 13 to produce the aforesaid agreement for proper adjudication and effective disposal of present disputes, and in order to avoid all sorts of controversies and doubts, with a direction for full disclosure of flats held by 13 as the same are required by this court. Court requires it. Now, Miller, that's not good enough. Written objections to the main application, so and so, and Miller, the vacation application of 13 under Order 39 Rule 4 will accordingly be heard and decided immediately after compliance of directions. So, Miller, till such time as Miller, the directions are complied with, this will not happen. Now, kindly have a look. Ordered. Defend number 13 shall produce the original so and so before this court by next day. Defend number 13 shall also file an affidavit disclosing full particulars of all flats at suit presently in its occupation or control, whether under original allocation recorded in 3rd schedule or on any other basis. Then the legal basis of occupation of such flat. Now, with the greatest of respect, this is beyond, my lord, Order 11 Rule 14. Then, my lord, copies. Now, what do I have to produce? Not originals. I have to produce copies of all instruments, deeds, agreements, arrangements, letters, correspondence, resolution, no objection certificate, circulation minutes, occupancy arrangements, any other documents pursuant to which defend number 13 claims to occupy or exercise any right in respect of each flat present in its occupation or control.
Completely.
Then, my lord, the application of defend number 13 under Order 39 Rule 4 shall be immediately heard and decided after compliance of directions 1 and 2.
Absolutely.
So, my lord, till, my lord, if I don't produce the original, it can't be heard. If I don't give the orders, my lord, it can't be heard. So, my lord, and now my learned friend says Order 39 Rule 4 is I have not produced these. I've come up before your lordship. And it won't be heard.
Order 11, 14,
Now, my lord, in fact, Order 11, Rule 14 was not even heard. We weren't allowed to file, my lord, an affidavit. The learned judge held I have the widest discretion. It's a procedural matter. Now, my lord, kindly see, my lord, clause 4 of the order, even more dangerous. The plaintiff shall file its written objection to the application of defend number 13 under Order 39 Rule 4 within 2 weeks of such compliance. So if I don't comply, it doesn't need to file, the interim order will, my lord, continue. Now, my lord, defendants who have not filed, etc. Now I came up, my lord, my lord, in appeal. My lord, kindly take, my lord.
70. 70.
My lord, it's at page 70 or the, my lord, last, my lord, document in volume 9.
Yes. Respect
My lord, usually, my lord, is the last annexure, which is the certified copy. This is, now, my lord, kindly see, my lord, third paragraph. Now the record is taken up for passing order in connection with prayer for ad interim stay of impugned order passed by so-and-so. Trial court was pleased. My lord, the production which I have read, then, my lord, kindly come to. My lord,
Quotes the order 70.
my lord, then, my lord, it is, quotes that order, it is not in dispute. My lord, next page, has filed a suit for declaration after, my lord, the direction, inter alia decree for declaration, etc., etc. As well as the application filed under Rata so-and-so for relief of interim injunction, the first order 30th April, which is why I placed it. My lord, which is a blanket order. My lord, nothing altering, my lord, transferring, my lord, nothing can be done.
72 তে আমরা বললাম no direction upon the appellant to file any written objection.
Then, my lord,
to the said
kindly
application under order 11 to 14. 72 মাঝখানে
72 to the yes. Now, my lord, kindly come to my learned friends reading from 72. I'm reading, my lord.
Oh,
My
sorry.
lord, as per tradition, my lord, the end of the, my lord, internal page 3. My lord. Kindly, my lord.
Yes.
Kindly come to, my lord, fourth line, my lord. Learned senior counsel appearing for the appellant prays for an ad interim order of stay of impugned order by learned
Page
trial.
3. At page 3.
My lord,
Page 3. Yes, 3 of 6.
Page 3 of 6.
3 of 6.
my lord, the fourth para, my lord, on consideration of the ground
Yes.
of objection cited in the memo, so and so it appears that above referred has been challenged in the instant misappeal. Learned senior counsel appearing for the appellant prays for an ad interim order of stay of impugned order dated 1st June passed by learned trial court citing grave urgency involved in the matter and submits that ad interim order of injunction was passed by the entitled suit and directed shall remain in force and thereafter on 20th entered appearance and made submissions objecting to extension of the order. It is submitted by plaintiff. Respond number 1 filed an application under Order 11 Rule 14. The learned trial court passed no direction on the appellant to file any written objection to the application under Order 9 Rule 14 and without providing an opportunity of hearing to the appellant, application filed under so-and-so was disposed of by the impugned order. It is submitted by learned counsel that ad interim order of injunction was extended while the application filed under Order 39-4 was kept pending. It is submitted that impugned order dated 1st June got extended from time to time without considering that in the event the order not being extended, plaintiff would not suffer any irreparable loss. It is submitted that by extending the order, learned trial court gave directions and had restrained parties in such manner which is contrary to statute, particularly section 58 of the Indian Trust Act. It is submitted that the plaintiff respondent ex facie, having acted in terms of declaration in trust executed by it being deed dated, was not entitled to any relief in the suit. It is submitted the learned trial court, in extending the order dated so and so by the impugned order, thereby deferring consideration of application under Order 39, Rule 4, filed by appellant, has caused a serious error, and accordingly order dated so and so is not. It is submitted that property in question, as held by plaintiff respondent as a trustee for syndicate members, according to syndicate agreement and declaration of trust executed in the year 1961, the syndicate members are true beneficial owners with exclusive rights to possess and transfer their interest without trustees' consent. It is submitted that while passing the order in the title suit, learned trial court ignored section 58 of Indian Trust Act, which permits beneficiary to transfer interest independently of the trustees. It has been alleged that the plaintiff respondent number 1 has deliberately suppressed the 61 syndicate agreement to obtain ex parte order. It is further submitted that suit is grossly undervalued or so and so. 60,000 and 300 plaintiff failed to establish a prima facie case. On the other hand, the injunction causes significant injury to beneficiaries' lawful rights. It has been further alleged plaintiff has not only failed to fulfill duties of a trustee, but has failed to maintain the property and has no standing to claim ownership or access to flats. It is submitted the learned trial court has heard by passing an order directing appellant for production of certain documents while deferring sanction. Accordingly, instant appeal fair has been made to set aside, etc. Then, my lord, kindly come to the next page. Per contra, learned counsel for plaintiff respondent caveato raises strong objection to prayer for granting and questions maintainability. It is submitted that the ad interim order of injunction passed has not been challenged in this appeal, and the appellant has only questioned the propriety of the order of the learned trial court regarding extension. Learned counsel submits appellant has questioned the order passed by the court while disposing of application under Order 11, Rule 14, and the said order cannot be challenged in this appeal either. He submits that any order passed by the learned trial court is revisable and not, and that's the revision we have filed. Learned counsel also submits there is no urgency warranting an interim order after impugned order of so and so or the suit itself. I've heard learned counsel for respective sides peruse the etc. Then, my lord, in order to obtain an ad interim order of stay, the appellant needs to satisfy the court that matter involves grave urgency and the appellant shall suffer substantial and irreparable loss if such an interim order. Now, with the greatest of respect, my lord, our Code of Civil Procedure does not talk about urgency. It talks about irreparable injury. My lord, and nothing can be more urgent than my statutory right. It's my lord, beneficial interest, over which, my lord, there's an injunction from 30th April. And I've been trying, to have it vacated. My Order 39, Rule 4, if I may use an expression, has been football. And my objection to extension, has been rejected without, appreciating, Section 58. Absolute, bar, to it continuing. The original order had no mention of 58. It was brought to, the court's notice that under 58, there cannot be a restraint against me. Forget about the syndicate agreement. In law and the declaration, of trust. Now, next. On a bare perusal of the order passed by learned trial court, it appears that application filed by appellant herein under so-and-so is still pending for consideration. Learned trial court appears to have only extended the interim order of injunction along with certain directions in terms of provisions contained under it. Needless to say that any order passed under Order 11, Rule 14 is an interlocutory order which can be termed as temporary or procedural in nature, made in course of trial, which is neither revisable under Section 1 nor appellable. It is glaring on the face of the record that interim order of injunction was, and thereafter interim order was extended from time to time. Why? My opposition was being heard. Then, meanwhile, appellant filed an application questioning grant on such order within scope and ambit, has filed an. I do not find any materials before this court at this stage to come to any prima facie finding that learned trials court order is arbitrary, perverse, and capricious, or has been passed in complete ignorance. What's the point of keeping the appeal after this finding? Having regard to overall facts and circumstances, I am of the considered view that appellant fails to show any grave urgency to avail an interim order of stay of operation of the impugned order without extending an opportunity to file written objection. Accordingly, prayer for interim order of stay is refused at this stage. Fix so and so. Now, my lord, two things. My lord, as far as the order, my lord, extending the interim order is concerned, my lord, a new ground has been taken, my lord, for extension. What is that? That section 58 cannot stand in the way, my lord, of, my lord, the interim order which has already been passed. That, my lord, I'm show your lordship, is completely perverse. It's completely, my lord, illegal. And, my lord, that itself, my lord, is the urgency. I've shown your lordship their own document, declaration of trust. It operates as estoppel against them. They are the ones who declared the trust. They are the ones who said, my lord, that beneficial interest is with, my lord, with the syndicate members. And, my lord, the common areas they are only holding, my lord, as a trustee, which they shall deal with as per directions of the syndicate members. He has no independent title. And what, my lord, I'm showing your lordship is what has been dealt with is only beneficial interest, not, my lord, the legal, my lord, title which is vested, my lord, in the trustee. And his prayer in the plain, my lord, is contrary, my lord, to the Trust Act and his obligations as a trustee, for which, my lord, we'll take, my lord, separate steps. But what I'm showing your lordship, on the face of it, my lord, there could not have been any interim order, let alone, my lord, an extension. And we are aggrieved, my lord, by the extension, which is why we went on appeal, which is why now, my lord, we have come on revision. My lord, two cases I want to show your lordship, my lord. My lord, kindly take 1942 insurance cases, page 1. You have, it's a AR 42 Madras, give either of the two. Actually, yes.
Yes.
Just give it to me, I'll find it.
Hyderabad.
My lord, it's also reported in, my lord, which might be easier to find. All India Reporter 1942 Madras 136.
Next to what?
136.
Yes. Now, my lord, kindly, my lord, take, my lord, page 6. My lord, fifth line from the top of page 6. The copy I've handed up, page 6. Under section 58 of the Trust Act, it is also clear that it is competent for a beneficiary to transfer his interest. The interest taken by the several defendants under the policies, though contingent, can be transferred because the right created under policies is not in the nature of a mere right to sue. My lord, your lordship recalls, my lord, Transfer of Property Act, mere right to sue can't be transferred. My lord, it's policy of insurance, my lord. It's contingent on the happening, my lord, of the event insured against. But, my lord, it is, my lord, capable of transfer, and a beneficiary of that, my lord, can transfer under section 58. And then, my lord, kindly take 1975, 4 Supreme Court cases, 360.
It is also.
My lord, 368. My lord, another tax case, my lord. Kindly come to para 10.
Okay.
Argument was also advanced by Mr. Manchanda that Princess Nilufar, who was a beneficiary under the trust, could not, your lordship has that, Miller, could not transfer her beneficial interest in favor of the SSE. This contention cannot be accepted in view of Section 58 of the Indian Trust Act, according to which the beneficiary, if competent to contract, may transfer his interest, but subject to the law for the time being enforced as to the circumstances and the extent in and to which he may dispose of such interest. The present case is not governed by the proviso to that section. That's, my lord, the married, my lord, lady. The proviso prevents a married woman from depriving herself during a marriage of a beneficial interest in property which is transferred or bequeathed for her benefit. As would appear from the resume of facts given above, Princess Nilufar transferred her interest not during the subsistence of a marriage, but at the time of this. The proviso didn't apply, was free to transfer. And that's, my lord, the my lord Supreme Court. My lord, there are several cases. I don't want to trouble your lordship. My lord, now, my lord, on the revision, my lord, which I have filed. Now, my lord, just to my lord, summarize, my lord, on my lord, the extension order. My lord, it is contrary to law, first. It is contrary to the deed of declaration of 16th August 1961. Now, my lord, kindly note one thing. This deed of declaration, clauses 1 and 2 are not considered at all, my lord, at the time of, my lord, exercise of discretion. Then, my lord, the deed of declaration does not require, my lord, the trustee to be a party in the event of transfer of a beneficial interest. Then, my lord, he is actually, my lord, the trustee is actually acting contrary to the interests of, my lord, the beneficiaries. My lord, he claims, my lord, the entire property now as his own without an extinguishment of, my lord, the beneficial interest, which he cannot. It's contrary to Section 14.
For being a trustee.
Then, my lord, the deed, my lord, which he relies on as an admission, only talks about transfer of beneficial interest. Does not talk about, my lord, transfer of, my lord, the trust property. And, my lord, that is 2005. From 2005, my lord, till, my lord, after 21 years, my lord, the trustee has not been in the picture.
An ex party identity order.
An ex party identity order, my lord, is obtained, my lord, which we then, my lord, apply, my lord, for vacating. And this is, my lord, what happens. So, my lord, in my respectful submission, my lord, there should be a complete stay, my lord, of, my lord, this order. And if they are to be heard, my lord, they can file affidavits, or, my lord, your lordship sets it aside, and, my lord, the parties, my lord, are, my lord. This cannot stand, my lord. It gives a bad name, my lord, to what is happening. Then the second, my lord, kindly have a look at Order 11, Rule 14, and I'll cite two cases.
last
Code. My lord, we have a copy, my lord, if your lordship wants.
শুধু লাস্ট পার্টটা দিন না, অন্য রিভিশনাল অ্যাপ্লিকেশনের শুধু লাস্ট পার্টটা দিন, সেকেন্ড রিভিশনাল অ্যাপ্লিকেশনের লাস্ট।
আর কি হবে? 72 টাকা আর কি রাখা?
সার্টিফাইড কোড।
Calcutta.
আচ্ছা, নিয়েছি সেকেন্ড সিভিল ডিভিশন।
Now, my lord, what are my grounds of challenge? One, I was entitled to be heard. I was not heard. Second, it's contrary, my lord, the directions which have been given without satisfying the conditions in Order 11, Rule 14. My lord, kindly have a look at Order 11, Rule 14. 72. Now, my lord, kindly take Your Lordship has the court, my lord. Yes. It shall be lawful for the court at any time during the pendency of any suit to order the production by any party thereto upon oath of such of the documents, kindly note this, in his possession or power. So, my lord, there has to be satisfaction that it's in the possession or power, my lord, of ITC, relating to any matter in question in such suit, as the court shall think right, and the court may deal with such documents when produced in such manner as shall appear just. Now, my lord, kindly have a look at their application, and then I'll, my lord, show, my lord, what has to be, my lord, followed. My lord, kindly take the plain, page 278. My lord, that's in the first. My lord, kindly take it from the first document. My lord, it's in volume 3, my lord.
Page 278.
Yes, 278. Kindly come to para 4. My lord, to start with, at page 287. First, I want to show your lordship that this is a document plaintiff has relied on. Now, kindly have a look. The plaintiff further states that lordship has that, my lord,
Yes.
287. That subsequent to the principal deed, an agreement dated 6 October 1961, hereinafter referred to as the syndicate agreement, was entered into between the plaintiff and the syndicate members, by which the then syndicate members constituting a syndicate named the Woodland Syndicate deemed to have obtained on and from 7th April 1959. Plaintiff states that syndicate agreement was an internal governance document of syndicate members constituting framework for inter se rights and obligations, and must be read as subordinate to principal deed and subsequent supplemental deeds which continued so and so, under which Schedule A property is held. Syndicate agreement by itself could not confer upon any syndicate member any right or power to transfer, convey, or sign any interest in suit property otherwise than through a duly executed registered so and so. Well, the argument is suit property. We are not concerned with that. We are concerned with beneficial interest. Then, Millard, otherwise than through a duly executed with the participation of plaintiff as trustee, title to the suit property having always been and continue to be vested exclusively. In any event, any alleged transfer of immovable property relying upon syndicate agreement is legally ineffective, inter alia under 54 of transfer of property, 17 of so and so, etc. Then, Millard, principal deed was subsequently, Millard, I'm not concerned with that. Now, Millard, kindly come to Millard 5.2. Millard, page 289. Supplemental deed dated so and so, registered at Kolkata Registry. This deed recorded that principal agreement dated 6th October should take effect as if the syndicate agreement had been in existence at the date of the principal deed. Now, Millard, kindly have a look at, Millard, the document itself, Millard, which I showed your lordship, recital 4, Millard. It talks of that. He himself is relying on it. Now, Millard, kindly have a look at their Order 11, Rule 14. Sorry, Millard, 5.6. Kindly come to 5.6. Also, Millard, 290. 9 supplemental agreement dated 10th September registered, recorded the current names and their respective and constituted the last registered so and so with participation under 3rd schedule, etc. And Millard, all this, Millard, is given. Now, Millard, kindly see what his case is. Plaintiff states that some of the original title and property documents in respect, including certain of supplement executed between so and so, have been discovered to be untraceable during plaintiff. So, Millard, 2005, last document. After 21 years, they've been found to be untraceable. So, what do they do? In April 25, file a complaint with the police that it's not available. Trustee has not been in the scene at all. He has surfaced now, Millard, for an obvious reason. Now, Millard, kindly have a look at their application. Millard, Order 11, Millard, Rule 14, application.
Okay.
Volume 7. Millard, kindly see it from there.
Thank you.
Page 903, Millard. My lord, kindly take paragraph 6.
Page.
Page 907. 906 it starts, 907. The plaintiff states that the original executed version of the alleged syndicate agreement dated so and so, bearing the original signatures, thereto is a document that is in the possession, custody, or power of 13, which has itself relied upon the agreement as the basis of the claim rights and has produced a true copy of Annexure C to its application. Defendant number 13 is accordingly a person, kindly note this, who has or may have the original document in their possession, custody, within the meaning of sense. So, my lord, has or may have. Not sure. Now, my lord, kindly take, my lord, the paragraph 8 now. The plaintiff further states that 9 supplemental declaration of trust that executed between plaintiff records 13 was holding a beneficial interest in 8 of the 40 flats being so and so. Defendant number 13 has not disclosed in the application. I'm not required to disclose. You are the plaintiff. You have to prove your case. Defendant number 13 has not disclosed in the application number of flats presently in its occupation or control, the identity of each flat, instrument or arrangement pursuant to which it claims to occupy any flat beyond its recorded allocation of 8 under 9, and this disclosure is directly relevant to and necessary for effective adjudication of application of 13, party seeking to vacate on the ground that its rights are beneficial holder, a beneficial interest beneficial currently holds, in respect of which specific flats and on what, in the absence of disclosure, learned court is being asked to vacate its considered order without being placed in possession of full and accurate picture of current possession. Accordingly, calls upon 13 to produce copies of all instruments, deeds, etc., etc. This is, my lord. Now, my lord, kindly have a look at, my lord, 2 decisions, my lord, I wish to rely on. My lord, first is, my lord, 1972, Calcutta. My lord, AR 72, Calcutta 308. My lord, paragraph 5. My lord, print page, if your lordship has the print page, my lord, page 3 bottom. My lord, kindly see last 4-5 lines. It seems to me that although the court undoubtedly has a power to make an order for production of documents at any time during the pendency of any suit, such an order can be made only if 2 preconditions as contemplated by Rule 14 are satisfied. Namely, that the documents must be in the possession or power of the party against whom the order is made. Pausing here. There is no finding that, my lord, by the order, in the order, my lord, impugned, that, my lord, this syndicate agreement is, my lord, in my possession and power. No finding. Then, my lord, and his application also, he's not sure. May, is, or may be. Now, my lord. And secondly, the documents must relate to the matter in question in the suit. Then it is amply clear from the text of the rule itself that wide power to direct production of documents at any has been given to the court, subject to the 2 conditions. Then, the court has therefore to be satisfied either upon admission of the party against whom the order is made, or from an affidavit filed on his behalf, or from other material, such as correspondence that the documents which are directed to be produced are in the possession and power of the party against whom order was to be made. To my mind, it seems to me, unless there is evidence before the court that the documents are in the possession or power of the party against whom the order is sought, the court will have no jurisdiction to make an order for production of the same. The second condition is also very relevant and important, namely that documents must relate to the matter in question in the proceeding pending before the court. Now, my lord, here there is, my lord, no evidence to show, my lord, that ITC is in possession of the original, my lord, of this document. In fact, the plaintiff, my lord, has relied on this document in his pleadings, but says it is subservient to the declaration of trust and supplemental declaration of trust. And I have confined my argument, my lord, on both declaration of trust and I have not gone to syndicate. Then, my lord, it also has to be satisfied that is necessary. Now, he is the plaintiff. He comes and says, I've lost everything. So, my lord, I am, my lord, to produce. My lord, this is clearly contrary to, my lord, another Supreme Court decision. 61 Supreme Court 218. Just give. You have a copy or not? I have a copy. 218. Got it. My lord, kindly, I'll come back to Padam Sen. Let them, my lord, find it. You found it? Very good. Give. My lord, kindly take para 9. Now keep the next one out.
That's fine.
My lord, paragraph 9. My lord, print page 3 if your lordship has that. My lord, last 10 lines above para 10. Lordship sees that, my lord. A sentence starting, a party is free. A party is free to produce such documents or books in support of its case as be relevant. A party can ask the help of the court to have produced in court by the other party such documents as it would like to be used in evidence and are admitted by that party to be in its possession. If a party does not produce the documents, it is, kindly note, lawfully called upon to produce, the court has the power to penalize it in accordance with the provisions of the court. The court has the further power to draw any presumption against such a party who does not produce the relevant document in its possession after it has been summoned from it. Even in such cases where the court summons a document from a party that has not been given any power to get hold of the document forcibly from the possession. Now, what has been done here? Assuming the order is right, my lord, and I do not produce, my order 39 rule 4 can't be heard.
Never heard.
I can't be forced directly or indirectly to produce, even if there is a direction. An adverse inference can be drawn. But, my lord, I go to the root. I say it had no jurisdiction to pass this order. Now, my lord, kindly see, my lord. My lord, then, my lord, roving, fishing inquiry not permitted. Now, kindly come to, my lord, the next decision, my lord, which is 1992. 1992, two Supreme Court cases, 612 at para 6 and 7. My lord, kindly take page 616, which is print page, my lord, 5. My lord, my lord, Placitum F, kindly see. Order 11, Rule 14, CPC empowers discovery and inspection of the records and Rule 14 as under. Then, my lord, para 7. The court, therefore, is clearly empowered and it shall be lawful for it to order the production by any party to the suit such documents in its possession or power relate to any matter in question in the suit, provided, now kindly note this, the court shall think right that the production of the documents are necessary to decide the matter in question. The court has also been given power to deal with the documents when produced in such manner as shall appear just. Therefore, the power to order production of documents is coupled with discretion, kindly note this, to examine the expediency, justness, relevancy of the documents to the matter in question. These are relevant considerations which the court shall have to advert to and weigh before deciding to summon the documents in possession of the party to the election petition. Well, this is an exercise which has to be undertaken. It's not undertaken at all. I have the power, widest discretion, and is justified. I will come and try and prove the case of the plaintiff. My lord, now, my lord, the last case, my lord, which I wish to rely on, my lord, is Achenani 2019. My lord, 2019 SEC online cal 6496, my lord, kindly take para 7. The Supreme Court, my lord, has been, my lord, followed. The court's power to order provides coupled with the discretion to examine so and so and the relevancy of the document to the as has been held by the Supreme Court. Now, my lord, in the instant case, kindly read the next. Execution of impugned deed of gift is not in dispute. Therefore, production of original document when certified are already been marked exhibit with a not at all relevant for. And here, my lord, it's a copy. It's being admitted to be a copy. Nobody is disputing that, my lord, it is, my lord, not a copy. And they themselves say that such an agreement is there. On what basis, without knowing the contents, do they say that it's subservient to the supplementary deed of conveyance, deed of trust? My lord, if according to them, my lord, they have said why, my lord, it is subservient. So, my lord, they know the contents. And it's necessary. Usually, my lord, these can be done at any stage of the suit. But usually it's at the time of trial, when, my lord, parties are going in for trial. All these cases, my lord, were either just before or during the course of trial. And now, my lord, the worst thing is, my lord, consideration of my 39.4, my lord, is football till I produce this. My lord, my humble submission, my lord, would be, my lord, stay for the time being, and my lord, later, my lord, your lordships, my lord, may consider whether to set it aside. But these two orders, my lord, cannot survive at all. In fact,
May it please your lordships. My lords, we are at a stage when your lordship is deciding whether to issue notice in the revision and whether to grant an ad interim, effectively ex parte stay without hearing my objections, which is what my learned friend wants. I submit, and I'll deal separately with items 4 and item 5. Item 4, which has to do with the extension, I want to show my lords ex facie, this is not a case either for notice to be issued or for an ad interim order. The reason I state it is this. What is the subject matter of the revision? The trial court said, I will hear your section 39.4. There is an ad interim order in order 39.1 and 2. You have filed a 39.4. I will hear your 39.4. Meantime, I'm extending an ad interim order already given. That ad interim order already given was not challenged in any manner whatsoever. And as I argue before my lord, it is still not challenged in any manner whatsoever. Now, the extension order which was passed is challenged before the appellate court. The appellate court, while entertaining the appeal, declines to pass again an ad interim stay of that order. In other words, stay has not been rejected. The court says, I am not giving you an ad interim stay without hearing objections. That's all we are at. That is the order before your lordships. My learned friend is arguing at length on the original order, which is subject matter of the appeal. But will you kindly see the impugned order? my learned friend would say there is no urgency contemplated in 39(1) and 2. I'm very sorry he should say so, because the first question your lordships always ask before granting an interim order is, what is the urgency to pass an order without hearing the other side? That is the first question your lordships ask. What is the urgency? Why should we not give the other side an opportunity to respond? This has nothing to do with 39(1) and 2. This has to do with the natural justice of hearing both sides, which at some time your lordship say no, because there's an urgency. I cannot decide this matter. I have to pass an order without hearing both sides. Now, what is before my lord? Your lordship will see the impugned order is at page 70 of volume 1 of item 4. Kindly see page 70.
Volume 1 কোথায়? Page 70.
Page 70.
Yes.
Today is fixed for passing order in respect to prayer of the appellant for an ad interim order of stay. Please notice the words. An ad interim order of stay. Appellant files Hazira through their learned counsel. Respondents 1 and 11 also file Hazira through their respective learned counsel. Now the record is taken up for passing order in connection with the prayer for an ad interim order of stay of the impugned order. Now the impugned order was an order extending an already existing injunction, not freshly granting an injunction. Extending an already existing injunction. Now you come before a court and you tell the court there was an interim injunction, ad interim injunction. I filed an order 39 rule 4. My order 39 rule 4 is pending. Meantime, the court has extended the interim order pending hearing of the 39-4. Shorn of everything else, my lords. Shorn of any things we may say, any allegations we may make regarding the correctness of the order. What it boils down to is, there is an ad interim order that is not challenged. You file a 39-4 to vacate that order. The 39-4 is slated for hearing. Meantime, the interim order is extended. Now you object to the extension. You file an appeal. In the appeal, you say, while considering my appeal, please grant me an ad interim stay. Please grant me an ad interim stay of the order by which an existing interim order was extended. This is what the case is. To which, what does the court reply? Please see at page 74. And whether this is perverse of the nature contemplated for your lordship's interference. My learned friend argued at length on the original order of interim injunction. That is not the subject matter of the appeal. He argued on extension and the order of extension. That is not subject matter of the appeal. Subject matter of the appeal is his appeal is pending before the appellate court and he wanted an ex parte stay order. The appellate court said, no, I can't grant you an ex parte stay order. I'll have to hear objections. And I will hear after the objections when? Today at 2 o'clock. Today. Now your lordship will please see page 74. I have heard counsel peruse the contentions made in the application, page 74, my lords, line, the third paragraph from the foot of the page. Peruse the contentions made in the application with reference to the ad interim order of stay of the impugned order. Now, please see whether there is any fault here. In order to claim an ad interim order of stay, that is without hearing the other side or giving them the chance to object, the appellant needs to satisfy this court that the matter involves a grave urgency. I ask myself, what is perverse in that? Before I pass an order without hearing the other side, I must be happy, I must be satisfied it's a matter of grave urgency. My lord, we all argue day in and day out, asking for ad interim orders. Even when pending notice or notice is issued by the court, we say, please grant us an ad interim order. without hearing the other side. Your Lordship's first question, what is the urgency? Now, this is found fault with and said this is not a ground under 39(1) and 2. And the appellant shall suffer substantial irreparable loss if such an ad interim order of stay is not granted in favor at this stage. What is the irreparable loss which they're going to suffer in the next few days if the other side is not heard? What is that irreparable loss? The word is irreparable. So A, it has to be urgent, that I eschew hearing the other side. 2, it is urgent because the loss is so irreparable that itself speaks to its urgency. Now, my lords, the court goes on to say, on bare perusal of the order passed by the learned trial court, it appears that the application filed before the trial court under 39(4) is still pending for consideration. Trial court appears to have only extended the ad interim order of injunction passed on 34/26, not appealed, not challenged, along with certain directions. I'll come to this part of Order 11, Rule 14 subsequently. Please see next paragraph. It is glaring on the face of the record that the ad interim order of injunction was passed on 34/26. That is relevant when the court is deciding whether there's a great urgency today without hearing the other side to pass an order. The said interim order was extended from time to time. Each time it was extended, it was not challenged. Meanwhile, the appellant filed an application under Order 39, Rule 4, questioning grant of such order within the scope and ambit of such provision, and the plaintiff respondent 1 also filed an application under Order 11, Rule 14. I do not find any materials before the court, this court, at this stage. At this stage is the operative words. To come to any prima facie finding that the learned trial court's order is arbitrary, perverse, and capricious, or has been passed in complete ignorance of settled provisions of law. Then, my lords, question of maintainability was raised by us. That is also there. But please see the next paragraph. Having regard to the overall facts and circumstances of the case, I am of the considered view that the appellant fails to show any grave urgency to this court to avail an order of interim stay of operation of the impugned order. Please note the next words. Without extending an opportunity to the respondent to file written objections. Accordingly, prayer for interim order stay is refused at this stage, that is ad interim, fixed 27/7/26, that's today. And please see the next words. For filing written objection and hearing of the stay application in presence of both sides. My lords, I ask myself a simple question. My lords is sitting in revision over this order. Is this order perverse? Is this order such as to occasion my lords to say, I have to interfere with this order? Or even if your lordship feels, maybe I will look into it. Is it a matter that your lordships will say, Mr. Sundaram, without hearing you, I'm staying the matter, without having your objection on record, I'm staying this order? My lord, let me look at the order. My learned friend has gone all over the merits of the matter, which I'm also going to deal with just succinctly at this stage. But before that, where is the relevance of that? Has he shown, my lord, that there is some reason why an immediate order without hearing me should be passed by your lordship? Without hearing me. Number one. Number two, has he shown your lordship any reason why the court was wrong in saying, look, I'm not rejecting your stay, but there's no such urgency that without giving them an opportunity of being heard, I should pass an order? Is that of the perverseness that we expect when calling for my lord's interference in revisional jurisdiction? That is my preliminary objection, my lords, to this entire matter being entertained by my lords. Secondly, even if your lordship entertains it, is it a matter where your lordships will similarly pass an ad interim order without giving me the opportunity to file a reply? To alter a status quo that has prevailed from April 26 now for 3 months. That status quo has prevailed for 3 months. They have shown nothing. There is no material to show, my lords, that in the absence of a stay today, something terrible is going to happen tomorrow. I can understand, my lord. It's a matter of if they say that they satisfy, my lords, it's a case where there's going to be an immediate encroachment or demolition. I'm going to break down their building. I can understand something like that. This is really saying, I have a good case, therefore, do not hear the other side. My lord doesn't know how good their case is till you hear me. So, my lords, I submit at the very outset, this is not an order for interference. And much as my learned friend would like to talk about the original order of ad interim injunction and the order of extension of injunction, neither is before my lords. The order of extension of injunction is also not subject matter of the civil revision petition. What is the matter of civil revision petition is the revisional court in that matter, the appellate court saying, look, I'll entertain your appeal, but I will not pass an order without hearing the other side. Other side will file an objection and I'll hear it on 27th, and so soon, today is 27th. And today, what are they doing, my lord? They're moving for adjournment there. They are moving.
Mr. Banerjee, why are you seeking adjournment there? Why don't you get the appeal heard? If it's fixed today itself.
My lord, have they, but great respect, my lord, have they filed a written objection? That also not filed.
Have you
Well,
filed
so-
your written objection there? Mr. Sundaram?
I'm ready for the matter to be argued today. We are ready.
Mr. Sundaram, if you
I'm
can-
stating it here and
that-
now.
I'll record that
Sir.
he's ready, because in any case, Mr. Banerjee, if it is fixed today and I also intervene today, it doesn't make any sense. There is an appellate forum where you have approached. The appellate court is in season of the matter. It is fixed today in the second half. In the first half, I intervene.
Well,
And if he is ready with the objection, I'll record that and I'll say that it should be disposed of.
we have not been served, my lord, any objection. My lord, the question, my lord, today with great respect, my lord, is whether, my lord, the order can stand or not. And my learned friends, my lord, all his submission, my lord, these yardsticks. Well, I don't know, my lord, why this yardstick was also not applicable when the ex parte ad interim order was obtained after 20 years.
I'll observe
Well, after 20 years, kindly see.
that the learned
Now-
appellate court will take into consideration the provisions. Because
Now we are told, where's the urgency? Why won't you stay? But look at, my lord, how the order was obtained.
or conversely, Mr. Banerjee, I can direct the learned trial court to proceed with your order 39 rule 4
My lord, I
application for
think,
hearing.
my lord, my respectful submission, my lord, is kindly, my lord, consider the matter, my lord, as the order stands now. Kindly, this court, my lord, kindly consider it.
Because this, Mr. Banerjee, this 27/7 today itself, in the second half, it's fixed for hearing.
My lord, nothing,
I'll intervene now. It doesn't make sense.
my lord, nothing, my lord, it's not, my lord, that, my lord,
I'll record. If it doesn't happen, still the courts are open. You can come back again. But today it is fixed. Today I intervene in revision and pass an order.
my lord, in revisional court, my lord, has to see, my lord, whether the order in the first place is correct or not.
That will only again be restricted to this order of not
Yes,
granting
yes,
stay.
my lord, the order,
I'll again send it
We-
back at the best that I
my lord,
can
we
do.
prayed for stay. We prayed for stay of, my lord, the order of extension. The 1st June order. My lord, we came up in appeal, my lord, against the 1st June order. Kindly see, my lord, whether the 1st June order, my lord, is worth, my lord, should stand at all or not.
But that is not subject matter of the appeal.
Yes, yes, that is the subject matter of the appeal.
That is at large before.
That is the
appellate-
subject matter of the appeal.
Yes, that
And
is
my lord,
at
we have
large
come-
before the appellate court.
My lord, we are only on the question of, my lord, an ad interim order of stay. My learned friend, my lord, has obtained, my lord, an ad interim order.
You go and make that prayer again.
We have done that. That's been refused. My lord, that's what's been
That
refused.
Mr. Sundaram.
In the,
Today itself. Today he'll hear again.
my lord, the ad interim stay has been refused, my lord.
That I'll set aside. This order I'll set aside, send you back to the appellate court. Argue for your ad interim again. Even if they file the written objection, they don't file the written objection. If the appeal itself is heard, it will be heard.
My lord will say that irrespective of the order passed on so and so date by the appellate court,
Sir,
matter
Mr.
is listed
Sundaram,
today to be heard today.
Mr. Sundaram, I shall set aside this order of 9th of July 2026, which is impugned in this revisional application. Remand the matter to the file of the appellate.
My lord, in which case your lordships are saying this was wrongly or perversely done. Whereas all the
Yes.
court has said is, I'll hear it on 27/7. If your
No,
lordships
no.
say, as the court has said, they are hearing it on 27/7,
There is
it
one.
shall be heard today. It
Mr.
shall be heard today. I cannot
Mr.
object to
Sundaram,
its hearing.
Mr. Sundaram, there are two stages. There are two stages in which injunctions are heard. One is ad interim, another is temporary. Now,
My
this was
lords.
at the ad interim stage, which has been refused. So there is one stage of refusal that they have suffered. Now, this refusal which they have suffered was at the cost of the learned appellate court not appreciating the provisions of section 58 of the
That
Trust
I
Act.
can satisfy, my lord, but I
Provisions of
don't want to
section
take
3.
your time.
No, then you,
My-
Mr. Sundaram, you will satisfy the learned appellate court there, as is apparent from the order now when he says that has been passed in complete ignorance of the settled principles of law. The
That
learned
I want to, sorry,
the
my
learned
lord.
appellate
Can I
court
show
does
my
not.
lord ex facie why that submission is wrong? I'll just satisfy my lord because I don't want your lordship to set aside an order on the feeling that there is a
Let him show,
legality.
let my learned friend
Please
show.
see section 3. Just take one moment. My lord, please take one moment. Please see section 3 of the Trust Act and section 58. Read the two together.
Section 3.
Section 3.
Yes.
A trust is an obligation annexed to the ownership of property arising from a confidence reposed and accepted by the owner or declaration. Author of the trust, trustee, etc. Please see what this says. The person who, my lord, kindly see the beneficial interest. My lord has the last 3 lines.
Yes.
The beneficial interest or interest of the beneficiary is his right against the trustee as the owner of the trust property, and the instrument by which instrument is called the instrument of trust. Therefore, the right is as to his beneficial interest. Now read that with section 13, which says a trustee is bound to maintain and defend all such suits and subject to the provisions of the instrument of the trust to take such steps as regard may be had to the nature or amount of value of the trust property may be reasonably. So that's a duty on me, which I seek to protect, including preservation of the trust
That
property.
is Mr. Sundaram in regard to trust property. He is about
Yes,
beneficial interest.
the point here is,
Trust property is separate from beneficial interest. The
yes.
the beneficiary has a beneficial interest in the trust property. It is not the
Now,
trust.
please see what my lord is absolutely right. So 58, he can protect his beneficial interest. He can transfer it. What has not been shown to my lord, most unfortunately, is that what has been done. My lord, just give me 1 minute. I won't take more than a minute of your lordship's time. Please see, my lord, please see the page 661 of volume 5. Please see 661 of volume 5. And then your lordship will be satisfied as to the complete illegality of the action which I'm complaining about. Please see page 661. Your lordship saw they have a right to transfer the beneficial interest. Even that, the trustee needs to be a party. Now, please see what they do. Page 661, this deed of conveyance I'm objecting to of 31st January 25. Please read it with me, just 2 clauses. My lord, kindly see at page 671. My lord, kindly see page 671.
Page 671.
Yes, 669, it starts that part. 2 clause 1.1. The last 4 lines. The seller, my lord, has that seller doth hereby sell.
Yes. Yes.
Convey and transfer to the purchaser all that flat number so and so, along with one covered parking place, etc., at measuring so much, described in second schedule hereunder, with all rights, title and interest therein, together with the right, title and interest of undivided 148 share in the land comprised in the said trust, and common passages. If you see the trust deed itself, it says common passages and only vest with the trustees, and common passages or staircases within the land which was being held by Woodland Syndicate as a trustee on behalf of the beneficiaries of Woodland Syndicate, being the syndicate members by virtue, along with the right to use in common. Now, please see what is Woodland Syndicate is not the trustee. I am the trustee. Even the declaration of trust is only what they showed you is only me. They are showing some Woodland Syndicate as being a trustee. Now, please see, on behalf of the beneficiaries of Woodland Trustee, a syndicate, and then by virtue of the declaration of trust, along with the right to use in common, etc., please see at the very foot of it, please see, and to have and to hold, own and possess the scheduled property and every part thereof granted, sold, conveyed, and transferred unto, and to the use of the purchaser absolutely and forever, freed and discharged from all encumbrances. Then please see the representations and warranties. Seller hereby represents warrants and covenants to the purchaser that it has exclusive and unencumbered legal, beneficial, and freehold rights, and is an actual possession of the scheduled property as well as the authority. How can it have? Now please see, it goes on to say, H, please see H at page 673. The seller has not been party or privy to any act, deed, or thing by which rights of the seller to deal with the scheduled property have been affected, abridged, or curtailed in any manner, and that the purchaser shall at all times, after the date of execution of this deed, peacefully, quietly hold, possess, use, and enjoy in its own right as the absolute owner of the scheduled property. Manu, this is against the very documents which they've relied on. I come to court. My lord is right in saying they have a right to transfer a beneficial interest. My point was, don't transfer it without my being a party to such a document because I am the legal owner. You want to transfer your beneficial interest, please go on. But I must also be a party. The 9 supplemental deeds that they have referred to, all were supplemental deeds where I was a party. I was a party. Not this kind of deed. Why I go to court is I say, look, it's done by supplemental deed. I'm a party. Then I can see what has been transferred. Someone comes in as a successor. Make me a party and do it. Now, my lords, I'm only showing you this to say that it's not as though the case is what is being made out. There is a very strong defense for my seeking this order. That's why I'm saying, my lord, it's not a matter of setting aside the order that it's against law. It's certainly not against law. This is what I came for an injunction against. In fact, what has been done is against law, is against Section 58. He cannot transfer freehold forever to hold as absolute owner, legal, beneficial, and otherwise. How can he do it? Now, my lord, that's why I read Section 13. My lord said 13 is your duty to hold to look after the trust property. That's why I read 13. It is my duty to come to court and say this cannot be done. It's my duty under 13. Now, my lord, it's not as simple as that. That's what I'm trying to say. My learned friend has for a long time. My learned friend did not show your lordship this document. What is the use of arguing? It's like playing Hamlet without the Prince of Denmark there. I've come forward and I said, look here, you cannot do this. We have been doing it by supplemental deeds 9 times. Let's continue doing it the same way we've been doing it in the past, where it's very clear that what's being transferred is a beneficial interest. Trustee is already also a party, has to be, because the trustee is the legal owner. If I'm the legal owner, my lord, I'm submitting, therefore.
If the appeal itself is heard out today as it is fixed for hearing today itself.
What is fixed is Order 39, Rule 4.
No, the appeal itself is fixed. 27th. Yeah.
1st June.
No.
The impugned order.
The impugned order, Gopal. The impugned order.
Already nothing will happen.
I'll direct them to appear before and the appeal should be disposed of today. Mr. Sundaram, please agree to hearing it out today.
I agree, my lord.
Then the order has to be set aside.
If the appeal itself is heard out, I'll observe that he will not be influenced by this order.
Oh, sorry, my lord.
I will direct the appellate court to hear out the appeal today without being influenced by these observations which he has made in this order.
Absolutely.
In the revisional
Certainly.
application. He'll
That
hear
is
out
one.
the appeal today and dispose it off.
Yes, that is one.
That can be done, Mr. Sundaram.
Certainly, my lord. Certainly, yes.
But my lord, no written objection is to be filed.
You have filed your written objection.
My lord, I am stating so on instructions that they will go ahead today. If they don't file a written objection before the time of hearing, they will nonetheless go ahead.
No, before
They'll
that,
nonetheless go ahead.
they have not filed anything.
You have as of now you haven't filed anything.
You filed your written objections? They filed it today. My instructions are it has been filed.
We will not
It is
They
affirmed, my lord.
haven't
We
received
can-
a copy, is what they are saying.
No, no, we don't have it.
It is affirmed, my lord. We can have
I'll
immediately.
have it. Please hand it over to them right now. My lord, my instructing counsels are there, my lord. They'll hand it over right now.
When do we
If
get
it
ready?
is served today, then in that case, I'll say in this week, it will be over.
No, no, it has to be done, my lord. The hearing has to commence today.
Today,
And-
hearing will
and-
commence today.
And my lord,
Since he is
Certainly.
being served- Since he is being served with a written objection today, in this week, it should be over.
Please, my lords.
And my lord, the revision, my lord, from
That I'll hear.
yes.
I'll finish this and then come to that so that I can get rid of this at least.
Order to set aside.
My lord, the
Mr.
order should be, my lord,
I'll say he will not be influenced by this order at all. This order will not be influencing the learned appellate court in hearing the appeal.
Please, my lords.
The order of this
Yes.
order by which he by
9th
which he-
July.
9th
Yes.
July
That
2026
order
order
doesn't
will
stand
not
in the way. Your
influence the,
appeal will be.
has to be, it can't influence him while taking the final
Yes.
decision.
Absolutely, I
Otherwise,
agree, my lord. I fully agree with your
it doesn't
lordship.
make any sense.
I fully agree.
This revisional application is directed against an order dated July 8, 2026, passed by the learned district judge, South 24 Parganas in misappeal number 174 of 2026. Full stop. Paragraph. The opposite party number 1 has instituted title suit number 607 of 2026 before the where is the title suit instituted?
Before which court? Which one?
Before the learned civil judge within bracket senior division, first court at Alipur, praying inter alia for decrease of declaration and injunction.
Yes. Good file.
Yes, my lord. Declaration and injunction.
Declaration and injunction. Full stop. In the said suit, the opposite party plaintiff also filed an application seeking injunction, temporary injunction under Order 39 Rules 1 and 2. Full stop. The said application was pressed for ad interim reliefs ex parte. Full stop. The learned trial court granted ex parte ad interim injunction against the defendants in the suit. Full stop. Paragraph. The petitioner, being the defendant number 13 in the suit, filed an application under Order 39 Rule 4 of the code, praying for vacation of the interim order of injunction passed by the learned trial court. Full stop. The said application, the application for vacating has not yet been heard, or
No, that's the
Not yet been heard, my lord.
it's been heard. The said application for injunction
Documents of direction.
has not yet been heard, and its hearing has been postponed till such time that the petitioner produces certain documents directed by the learned trial court on the opposite party plaintiff's application under Section 11, Order 11, Rule 14 of the code. Full stop. Paragraph. At a time when the ad interim order of injunction that had been initially granted on April 30, 2024 and subsequently extended, was supposed to be further extended, the petitioner filed an objection to such extension. You filed an application, objection to the extension.
Objection to extension.
Objection to the extension. Full stop. Paragraph. The application said objection against the extension of the injunction order, was heard by the learned trial court, and the objection was overruled by an order dated June 1, 2026. Full stop. The ad interim order of injunction stood extended. Full stop. Feeling aggrieved thereby, the petitioner approached the learned appellate court by filing misappeal number 174 of 2026, full stop, paragraph. In the said misappeal, comma, the petitioner filed an application praying for stay of the order extending the order of injunction, full stop. The said application was heard by, the said application was pressed ex parte before the learned appellate court on July 9, 2026, full stop.
My lord,
They
they
were
were appearing,
not expert.
It was not ex parte.
No,
No.
I think my learned friend said expert. No, it was not expert.
not ex parte, they were present.
Yes, there is.
No, I was asked to file objections. It was a first
No,
hearing.
you were present. People asked prayed for
I
it.
took notice and have been asked to file objections.
Application was, this said application
Very
was
correct.
taken of ex parte ta kete din. This said application was taken of for hearing on July 9, 2026. When after hearing the parties, comma, the learned appellate court refused to pass an ex parte, refused to pass an ad interim order of stay of the order of extension of injunction, full stop. The matter has been fixed for hearing today, i.e. July 27, 2026, full stop, paragraph. Being aggrieved by the said order, refusing to stay the operation of the extension of injunction order, comma, dated July 9, 2026. The petitioner has approached this court by filing the present revisional application. Full stop, paragraph. Mr. Mukherjee, learned senior advocate appearing for the petitioner, has taken several points assailing the order of injunction or of extension of the order of injunction, full stop. Primarily, comma, it has been contended that the order impugned before the learned appellate court could not have been passed in the teeth of the provisions of Section 58 of the Indian Trusts Act, full stop. It has been submitted that the learned trial court has failed to appreciate the difference between the beneficial owner and the trust property as defined under Section 3 of the 1882 Act, full stop, paragraph. Should I refer to all these judgments or?
Kindly do, because we'll cite it there also.
Yes.
And we'll
referring to a judgment of the Honorable High Court at Madras in SM ENAYA TULLAH Inayatullah Saheb SAHEB versus S.A.K. Jilani JEELANI SAHEB, reported at AIR 1942 Madras 136, comma. Mr. Mukherjee submitted that in terms of Section 58 of the 1882 Act, comma, a beneficiary is competent to transfer his interest, full stop, paragraph. CIT Hyderabad versus Nawab Mir Barkat BARKAT Ali Khan Bahadur, reported at 1975 4 SCC 360, comma, was also cited in support of the contention that a beneficiary, comma, if competent to contract, may transfer his interest subject to the law for the time being in force as to the circumstances and extent in and to which he may dispose of such interest, full stop, paragraph. He has taken this quote through the through the deed of conveyance executed on
My lord, the declaration of trust, my lord, dated 16th August 61.
this was cited to show their admission as regards record the transfers of beneficial interest by the beneficiaries, that is
Yes, my lord.
syndicate members.
16th August 1961, declaration. Oh, supplemental declaration of trust, 9th February 2005.
Yes. Now this page 748, the document beginning at 748, page 753.
Yes, my lord, that is my lord, conveyance.
Yes, this conveyance you cited to show that the record the transfers of beneficial interest by the beneficiaries,
No,
that
my
is
lord,
syndicate members.
no, my lord, that's conveyance.
Yes, you said that this was the admission that you had made, that yes, it was to record transfers by beneficial interest.
740.
Yes,
Correct me if I'm wrong.
753.
yes, my lord, 7,
Clause 7 at page 753.
correct. Correct.
What were the other deeds?
My lord, one is the declaration of trust, my lord, 16th August 1961, page 1124, volume 9.
Volume 9. Seven, 9. 1124. Yes. He has taken this quote through the declaration of trust dated August 16, 1961 to demonstrate that syndicate members would include the syndicate members for the time being of the syndicate. Full stop. Paragraph. Clause 1 of the said deed was cited to demonstrate that each syndicate member would have exclusive possession of the flat or flats and or outhouses so allocated, and such member would be entitled to exercise all the rights incident to such ownership. Full stop. Paragraph. Clause 3 of the said declaration of trust was shown to assert that upon dissolution of the syndicate, the trustees would deal with the servient property in such manner as the syndicate members shall direct. Full stop. Paragraph. This is for a different purpose. So many documents are there. Did by him. The deed of conveyance dated June 9, 2017 was shown to indicate that only beneficial interest as a beneficiary under the trust had been transferred. Full stop. To sum up, comma, it was submitted that what pattern kothay gelo? The space is less for accommodating so many documents. All get lost. That the order granting injunction was granting injunction and extending the same were contrary to law. Full stop. Paragraph. It was submitted that the act of the plaintiff is contrary to the deed of declaration dated August 16, 1961, and that the learned trial court did not consider clauses 1 and 2 during granting or extending the order of injunction. Full stop. Paragraph. It was further submitted that the deed of declaration does not require a trustee to be a party to the conveyances, and that the trustee was acting contrary to the interest of the trust in claiming all the properties as owner. Full stop. It was submitted that such act of the trustee was in direct contravention of section 14 of the 1882 Act. Full stop. Paragraph. Mr. Sundaram Learned, senior advocate, appearing for the opposite party. You are appearing for all the opposite parties, Mr. Sundaram?
Only one, my lord. Respondent number 1.
Opposite party number 1.
That's the trust.
Supported the order impugned. Full stop. He took the court through the supplemental declaration of trust dated 10th February 2005 to demonstrate that the entire that the trust property was being transferred by the beneficiary, claiming to be the owner thereof. That was your contention.
My lord, I took my lord through the document at page 661, which is dated 31st January 25.
661.
And I am saying 31st, page 661,
661.
volume 5, dated 31st January 2025.
661, yes.
Dated 31st January 2025.
Oh, document deed of conveyance dated 31st January 2025.
Which shows that, whereas I'm saying it should only be done as was done in the past through a supplemental trust deed in which the trustee is also a party. R1 is also a party.
To demonstrate that the 2025 conveyance, has taken a divergent course in not making the trustee as a party to the conveyance
and giving a absolute title, not just beneficial interest.
I said, and wherein, the beneficiary has claimed to be the owner of the trust property.
Yes.
Full stop. Paragraph. It is further submitted, that the order impugned is not in any manner perverse or arbitrary, warranting interference under Article 227 of the Constitution of India. Full stop. It is submitted that today itself, the matter is returnable before the Learned Appellate Court for hearing out the appeal, full stop. Mr. Sundaram submits that the written objection on behalf of the you are the plaintiff.
Plaintiff. I'm the
Yeah.
plaintiff. So it's
Written
my objections which is relevant.
Half of the plaintiff is ready, and it shall be filed today.
It has been filed.
We don't
I
have.
understand it's been filed in the court. Copy will be given to has been given to my learned friend, I think.
Will be filed.
No,
It shall be filed in court today. You please hand over. Hearing will start today, and it should finish this week.
Yes.
Please, my lords.
Full stop. However, comma, Mr. Sundaram, Mr. Sundaram, I am recording this, that you have agreed to the hearing continuing from today itself and for it to be concluded this week.
Yes, my lord. Please do. I did say it and I should stand by it. My lord, once I've said it, my lord, the question of your lordship's recording it, I can never object to. I did say it.
Both Mr. Mukherjee and Mr. Sundaram agree that irrespective of the written objection being filed today, the hearing of the appeal will commence today, and if it is not concluded today, comma, the learned trial court would be requested to complete the hearing. At least
appellate court
would be is requested to complete the hearing within a week from date. Full stop. Paragraph. Since this court, although comma, this court has recorded the arguments made by the learned senior advocates appearing for the respective parties, comma, it is clarified that this court has not gone into the merits of the matter, and all points are left open to be decided by the learned appellate court without being influenced by the order dated
9
July 9, 2026, which has been impugned in the present revisional application. Full stop. The learned appellate court would consider the matter on the basis of the material on record and the submissions made by the parties, irrespective of the opinion formed by the learned appellate court at the prima facie stage when the order dated July 9, 2026 was passed. Full stop. With the aforesaid observations, CO 2396 of 2026 stands disposed of. No costs.
My lord, only one thing. My lord, pendency of the appeal, my lord, will not prevent, my lord, the beneficiaries, at least, my lord, defend number 13 from taking steps against, my lord, the trustee.
Yes.
So kindly, my lord, provide.
The pendency of the appeal will not prevent the trustees, the beneficiaries of the trust from taking such steps as may be available to them in accordance with law.
Please, my lords.
I'll reframe the language.
as against the
I
trustee.
don't think it's needed, my lord. It's very clear.
As
Your
against
lordship
the
said.
trustee, but as against the
As
trustee.
against the trustees, beneficiaries as against the trustees. Yes, Mr. Sundaram, on the second
Yes.
application.
I think second point, my lord, there seems to be I don't know, it seems to be a complete error in the entire submission. Let me explain why. They say that I myself pleaded the existence of a document.
Jhamila.
They say that I myself pleaded the existence of a document where, and in Order 11, Rule 14, the question of requiring production of the document at the hands of the respondent was not called for. Of the petitioner before my lords, the defendant was not called for. There is a basic factual error in what my learned friend Mr. Mukherjee has said. Please see page 287 that he relied on to show that my pleading admitted such a document. Please see page 287. He goes on this pleading and says when they themselves admit the document, why should I be called upon to produce it? 287. (287), my lords, is a volume 3, I think.
Volume
3.
Volume 2.
Paragraph 4.
(287), paragraph 90, 91 and 92 are there.
No, my lord. I'm on volume 3, page 287. That is the plaint in the suit.
Revision he's referring from the previous.
2396. So, sorry, they're referring.
I'm sorry, my lords. I'm referring to CO 2396.
Same paper.
I just referring to the same volume, my lords, as your lordships referred to in the earlier item 4. My lord, Mr. Mukherjee also had referred to the same page 287.
Yes.
Kindly see paragraph 4. He says, look, they have admitted the document. After that, where is the question of my producing it? That is one point, and I'll deal with the second point also.
Yes.
287, paragraph 4.
287, paragraph 4. Yes.
The plaintiff further states that subsequent to the principal deed, an agreement dated 6th October 61, hereinafter the syndicate agreement, please note the next words, was entered into between the plaintiff and the then syndicate members. My lord has those words. So
Yes.
an agreement was entered into between the plaintiff and the then syndicate members, by which the then syndicate members constituted a syndicate. I am referring to a document of 6th April between the plaintiff and 6th October and the then syndicate members. That is, the plaintiff is a party. My learned friend says you have admitted that. Where's the question of objecting? But that is not the case, because what is the document they produced? They produced an unregistered, unsigned, unstamped agreement, typed copy with no signature, no nothing, at page 1086 of volume 9, and relied on this to say that they had their right. They placed their right in the 39.4 under this document. They produced it, stating that by virtue of this document, they had a right. So their whole defense to my injunction application and their attack in the 39.4 was based entirely on this document, which you see at page 1086. Please see who are the parties. The plaintiff is not a party. This is not the document referred to in paragraph 4. The plaintiff is not a party to this document. Now, they relied on this document to which the plaintiff is not a party, and kindly see at the very end, this was a typed copy, unsigned, unstamped, unnotified, anything, but mainly it was totally unsigned. At page
But Mr. Sundaram, paragraph 4 says your own government says that it was entered into between you and the syndicate members.
Which?
Paragraph 4.
Yes, that is not this agreement. This is not that agreement. The agreement they have produced at page 1086 is not that agreement. Please see, it's clear. 1086, the plaintiff is not a party to this agreement at all. The date may be the same, but this is not the agreement. This is amongst themselves. Plaintiff is not a party. My lords, kindly see page 895, their own pleadings at volume 7, page 895 of the 39.4, page 895 of volume 7. D.
895.
895 D. Last two lines.
Yes.
The syndicate members of the defendant 1 executed a syndicate agreement of 6th October. This is not with the trust. What I was referring to is the plaintiff, that is the trust, and the syndicate members. They are referring to a document which the syndicate members have between themselves entered into. And that document, your lordship finds at page 1086 of volume 9. This is what they produced, referring in paragraph 6D to this document. They produced this document and based their defense on this document. Now, my lords, what is important is this is not the same document. Now, what happens? They plead the document, they produce a copy, not a photocopy, a typed copy, not a signed copy. Please see at 1086, you will find the document, and you will find that the document at page 1106, starting at 1103, you will see, my lords, this is what they produce. They produce it just typed like this. At 1103, SD, signed. They don't file a signed copy. Again at 1104, none of them has signed it. So they produce a typewritten copy purporting to be signed by merely saying SD. So I say, look here, if you are relying on this document, please produce either the original or secondary evidence or whatever evidence of this document. Now, my lords, the matter is very easily solved. I don't know why we're making a mountain out of a molehill. Mr. Mukherjee takes your lordship to a number of judgments and says that under Order 11, Rule 14, the document must be in their power and control. Let him say it's not in my power and control. And let him not produce it. Obviously, if it's not in my power and control, a court directing me not to produce it. And I will draw my adverse inferences based on that.
But then before that, Mr. Sundaram, the court has to come to a conclusion that it is within his power and possession.
That is my point.
But that finding is not there, unfortunately, in the trial.
Exactly. So I am submitting, my lord. Let him tell the court it's not in his power and possession.
No, Mr. Sundaram, the court has to revisit the order upon giving them an opportunity, because this court's decision
to produce to place his defense. I don't mind. I have no problem, my lord.
This order 11, Rule 14 has to go.
Your lordship is saying the same objection I am saying. Your lordship is saying it's without his being heard. My lord is saying that it's passed without his being heard. That I can't plead two different opposite cases in case 4 and 5. If his objection is that I should have been heard before the orders passed, your lordship will merely set it aside without expressing any merits and say pass the order after hearing him.
Because if I'm sending it back for reconsideration, it will not be behove proper for the judge to express merits and then send back.
That's why, my lords, you please say reconsideration only because they have not been heard. Give them an opportunity of being heard. My lord, at least one thing I'm consistent. I don't plead one thing in the case 4 and another thing in case
5. This revisional application is directed against an order dated June 1, 2026, passed by the learned civil judge within bracket senior division, first court, Alipur, South 24 Parganas, whereby the opposite party plaintiff's application under Order 11, Rule 14, held in Section 151 of the Code of Civil Procedure, 1908, has been allowed by directing the petitioner within brackets defendant number 13 to produce originals of.
I'm sorry, my lord. Can I excuse myself? I've just been called in a court.
Yes.
Can I excuse myself?
Yes.
I'm obliged.
Originals of certain documents referred to in the said application under Order 14, Order 11, Rule 14 of the Code. full stop, paragraph. Title suit number 607 of 2026 has been instituted by the plaintiff, opposite party. Number one, praying for decrease of declaration and injunction, full stop. In the said suit, comma, along with the plaint, comma, an application for injunction under Order 39 Rules 1 and 2 was filed. Full stop. The learned trial court granted ex parte ad interim injunction, which was kept extended from time to time. Full stop. The petitioner filed an application under Order 39 Rule 4, seeking vacation of the ad interim order of injunction. Full stop. At this juncture, comma, after your application under Order 39 Rule 4, this Order 11 Rule 14 was filed.
Your Lordship's pardon.
This Order 11 Rule 14 was filed after your Order 39 Rule 4.
Same day. 20th
Uh,
No, my lord, same. They were filed, my lord. They filed 39-4 and we filed Order 11, Rule 14, my lords. Then it
On the
was
same day.
decided by order dated 1/6, my lords, whereas there was extended. Our injunction in our favor was extended and this
Right.
was application was allowed. It's a common order. Extension plus Order 11, Rule 14.
simultaneous with the petitioner filing the application for vacation of the ad interim order of injunction, comma, the opposite party number one filed an application under Order 11 Rule 14 of the code. Full stop, paragraph. The said application for order for production of certain documents under Order 11 Rule 14 of the code was taken up for hearing by the learned trial court on June 1, 2026. And the same was disposed of on the same date by directing the defendant number 3 to produce certain documents which have been mentioned in the order impugned. Full stop, paragraph. Feeling aggrieved by the said order, comma, the petitioner has approached this court by filing the present revisional application. Full stop, paragraph. Mr. Mukherjee, learned senior advocate appearing for the petitioner, submits that the order passed by the learned trial court is palpably bad, inasmuch as the same does not satisfy the mandatory prerequisites of Order 11 Rule 14 of the code. Full stop, paragraph. Having placed the provisions of Order 11 Rule 14 of the code, comma, it was submitted that before passing an order, comma, directing production of documents, comma, the learned trial court must of necessity be satisfied about two conditions. A, that the documents are in possession or power of the party against whom the order is made, and B, that the documents relate to the matter in question in the suit. Full stop, paragraph. In support of his such contention, now it is further submitted that such order can only be made, comma, if there is admission by the party against whom such order is made, or if it is evident from an affidavit filed on his behalf, or from any other material such as correspondence, that the documents which are directed to be produced are in possession or and power of the party against whom the order is made. Full stop, paragraph. In support of his contention, comma, he relies on a coordinate bench decision of this court reported at AIR 1972 Calcutta 308 India Foils Limited versus the 5th Industrial Tribunal, comma, West Bengal and others. Full stop. West Bengal and others. Full stop. He next relies on another coordinate bench judgment of this court in Amulya Dhan AMULYADH Amulya Dhan Hait HAIT versus Dinesh Hait and another, reported at 2019 SCC Online Cal 6496, full stop. Two judgments of the Honorable Supreme Court in, comma, Padam Sen and another versus State of Uttar Pradesh, reported at AIR 1961 SC 218 and Basanu Gouda BASANA GOUDA versus Dr. SB Amarkhed and others, reported at 1992 2 SCC 612, were also cited to indicate the scope of Order 11 Rule 14 of the code. Full stop. Paragraph. Mr. Mukherjee has taken this code through the pleadings of the opposite party number 1 in the opposite party number 1's application under Order 11 Rule 14 to demonstrate, comma, that even the opposite party number 1 is not sure as to whether the documents are in possession of the petitioner or not. Full stop. Paragraph. Full stop. It is further submitted by Mr. Mukherjee that the document which has been produced by the petitioner has been relied on by the opposite party in the opposite party's own plaint case. Full stop. Paragraph. Mr. Sundaram, learned senior advocate appearing for the opposite party number 1, submits that while the date of the document which has been mentioned by the plaintiff in the plaint matches with that of the document which has been produced by the petitioner with the petitioner's application under Order 39 Rule 4 of the Code, comma, the content of the document produced by the petitioner is different from the one that has been referred to by the plaintiff in the plaint. Full stop. It is submitted that the document on which the plaintiff has relied on is one to which the plaintiff is a party, while the document on which the petitioner placed reliance in the petitioner's application under Order 39 Rule 4 does not mention the plaintiff's name as a party. Full stop. Paragraph. Heard learned senior advocates appearing for the petitioner and considered the material on record. Full stop. Even if, comma, all arguments as regards merits of the cases of the parties are ignored, comma, it would be evident that the learned trial court has proceeded to pass the order under Order 11 Rule 14 of the Code without affording any opportunity to the petitioner to use an affidavit against the application filed by the plaintiff. Full stop. Paragraph. India Coils Limited Tupra has clearly held that for the court to exercise the power under Order 11 Rule 14 of the Code, comma, the courts must be satisfied that the documents are in possession or power of the party against whom the order is made, and that the documents relate to the matter in question in the suit. Full stop. The order impugned does not record any satisfaction to the effect that the documents are in possession and power of the petitioner before directing the petitioner to produce such documents. Full stop. The same judgment also holds that the satisfaction of the court must be reached either on admission of the party against whom the order is made, or from an affidavit filed on his behalf, or other materials such as correspondence, that the documents which were directed to be produced are in possession or power of the party against whom the order was to be made. Full stop. In the case at hand, comma, since no opportunity to use any affidavit against the petitioners, against the opposite party number one's application under Order 11, Rule 14 of the Code was ever granted to the petitioner, comma, there was no occasion for the court to derive satisfaction on the basis of the opposite parties, on the basis of the petitioner's affidavit, full stop. There is no material on record to conclude that there was any admission on the part of the petitioner that the document is in the petitioner's possession or power, full stop, paragraph. In such view of the matter, comma, since the order impugned has been passed without granting any opportunity to the petitioner to object to the application under Order 11, Rule 14, comma, made by the opposite party in accordance with law, comma, the order deserves interference, full stop. Accordingly, comma, the order dated June 1, 2026, passed by the learned civil judge, comma, within bracket senior division, comma, first court at Alipur, district South 24 Parganas, in title suit number is set aside, full stop.
Insofar as, my lords, paras number 1, 2, 3 are part of the order, because there are orders, it has 6 different paragraphs. This part of the order.
That has already been clarified in the opening portion of the order. I'll re-clarify.
Yes, my lord, just for clarification. 167, my lords, will find that, my lords, only 1, 2, and 3.
It is clarified that the order date, that the order setting aside the order would stand restricted to the portion whereby the petition, the opposite party numbers one's application under Order 11, Rule 14 of the Code was allowed. Full stop. Paragraph. Should I fix time frame here only for you filing?
Yes, my lord, we'll file our affidavit.
My lords, and let it be decided in a time-bound manner, my lords. This one also, like the earlier matter.
Since both parties are there before this court, comma, let affidavit in opposition stroke written objection to the application under Order 11, Rule 14 of the Code be filed within 2 weeks from date. Full stop. The learned trial court shall thereafter fix a date for hearing of the application under Order 11, Rule 14 of the Code, according to the convenience of the learned court, upon notice to the parties.
But, my lord, this also has to be decided in a time-bound manner, my lord, because this will have a bearing on the injunction also. I'll explain, my lords, and one request where my lords have recorded our submissions that we are not parties to that document, my lords. We had, Mr. Sundaram had made 2 submissions, my lords. First was that the plaintiffs were not parties to that document, that agreement which is sought to be produced. And secondly, my lords, neither a original copy nor a photocopy has been produced of that document, which they are relying on. Their defense is that document. So that is the submission, my lords.
It is further submitted by Mr. Sundaram, learned senior advocate appearing for the petitioner, that the document which was produced with the petitioner's application under Order 39, Rule 4 was
neither original nor a photocopy.
Neither the original nor a photostat copy of the original. It was a typed copy which did not contain signatures, and as such, comma, a direction for production of such document, original of such document, was felt necessary. Satisfied?
Original or photocopy / photocopy. My lords, it can be primary, it can be secondary also, but they have to produce some.
Next. That's all I have disposed of, setting aside that order.
And my lords, only one more request, my lords, small request, because this will have a bearing. Because, my lords, I'll explain. Because, my lords, this also has to be within time bound. Let them file an objection within 1 week. Trial court to decide in 2 weeks thereafter, my lords. That's all I'm requesting.
2 weeks. They'll file it within 2 weeks.
And trial court to decide within 2 weeks thereafter, my lords. That is my humble request, my lords, because that will have a bearing, because their entire defense is this document.
Mr. Counsel, the trial court will do it according to its convenience. I cannot settle the diary of the trial.
My lords are right, but in item 4, because my lords, in the appellate court, my lords have stated that let this go on. We have no objection.
It was fixed today. I don't know when the matter is fixed there.
Yes, my lords.
Matter is fixed after production of documents.
So
then affidavits will happen.
Yes, let this be decided first. Let this be decided first. No problem, my lords.
No, no,
My lords are right.
Your such and such disposed of.
My lords, grateful, my lords.
Thank you.
The next matter.
Shobhiti, affidavit of service filed in court today is taken on record.
My lord, we file the affidavit.
Right, item number 6. It's a
My
very
lords, I am appearing in item 6 also. Please do not disconnect me, my lords. I am for the opposite party in item number 6.
The same plaintiff.
matter.
Same plaintiff.
Kindly takes it up.
My lords, in this, I have a request, my lords. They need to serve us a copy, my lords. They need to serve us a copy. Twice we have asked them to serve a copy. Please let them serve a copy. Have this matter tomorrow or day after, my lords. Day after. Tomorrow I'm in some personal
So
Let
caveat,
them serve me a copy, my lord. That's my only request. Please serve me a copy and please have the matter day after, my lords. Tomorrow I'm in some personal
Defamation.
my lord's defamation suit, matter settled. Then, my lord, when the matter comes up, my lord, it says, my lord, there's a statement made from the bar that, my lord, my clients are in breach of the settlement. Therefore, my lord, suit is not disposed of. My right to file written statement taken away. My right to file a reply to the order 39 taken away. This is unheard of.
And same thing.
My lords, I can reply to that straight away, my lords. Let them supply me a copy. Otherwise, I can reply to that straight away right now.
They are not on caveat. We have moved, my lord, and my lord, your lordship will, my lord, hear.
Direct us to serve.
Yes,
Whenever
your lordship can direct us to serve certainly, but my lord, no further
Please have
proceeding.
it day after, my lord. That's all I'm requesting. Please have it day after, my lords. I will answer. Let them supply me a copy.
August.
I beg to appear for respondent OP1.
My lord,
এই বেঞ্চটা খুব ডেঞ্জারাস
my lord, there'll be a put up, no further steps in the proceedings. My lord, they don't go by date. It's the same learned judge, my lord. Kindly have a look.
Looks to be
My lords, let them supply me a copy. Otherwise, my lords, if my lords are keen to pass any order, then my lords will please.
Mr. Counsel, don't proceed till day after tomorrow. I'm fixing it day after tomorrow. It will be served on you.
Yes, my lords may not say anything. My client is here. I have told him, please not stay. Our hands still.
I'll record that the proceedings will not be undertaken before this matter is made returnable.
Yes.
I'm making it returnable day after tomorrow.
My lords, certainly.
On 28th.
Yes.
My lord, certainly. 29th, my lord, day after.
लिखे your name isn't showing on the.
I'm Abhishek Gupta, my lords. Abhishek Gupta. I'm sorry, my lords. I was assisting Mr. Sundaram in earlier matters.
Advocate appears and submits that he has instructions to represent whom?
OP1.
OP1.
Who's the plaintiff?
Party number 1, i.e. the plaintiff in the suit. Full stop. It is submitted. He requests for service of a copy. Full stop. Mr. Mukherjee, learned senior advocate, submits that he is not on caveat. And there is an urgency. Full stop. Paragraph. Since Mr. Gupta has entered appearance on behalf of the plaintiff opposite party number 1, let a copy of the revisional application be served upon Mr. Gupta by tomorrow.
My lords.
Full stop. List this matter. Day after tomorrow. New motion.
Email ID.
Paragraph. In the meantime, comma, if since the it is noticed that the
tomorrow. But it's not listed also. My lords need not say anything. Tomorrow or day after, it's not listed. So, my lords, since the date is.
It is noticed that the
you can have a
next
put up
date,
there.
that the next date of the proceeding is fixed on August 20, 2026.
Right, my lords, right.
In such view of the matter, comma, no interim order as of now is being passed. I'm recording this since it is returnable on 20th of August.
My lord, put-ups which happen. My lord, no further steps in the proceeding for 2 days.
My lords, now that is unfair, my lord. That is unfair, my lords. 20th August, my lord, the matter is listed. I am here, my lord. I am not running away. Day after, my lord. Let them serve me, my lord. Let them argue on ad interim, my lord. That is not fair.
My lord, kindly, my lord. Kindly, my lord.
Mr. Mukherjee is always very fair and kind, my lord. No, but this time, my lord, on this one, my lord, this request. Day after, my lord, in the matter is on 20th August.
Please say that you will not move anything in,
Yes, make a statement,
in the meantime.
As my lords pleases. In the mean, my lords, till day after tomorrow. Then make it till day after tomorrow, my lords. Because it can't be, my lords, supposedly that they carry on with this order. My lord knows how it happens.
Only till day after tomorrow.
My lords, my lords. We
So
will
I'll-
not take any steps till the next date of listing. That is 29th of July.
Mr. Gupta, learned advocate appearing for the petitioner, submits that
For the opposite party.
for the opposite party, number one, submits that his client shall not take any steps till July 29, 2026, when the matter has been made returnable. Right?
My lords, grateful, my lords. My lords are very kind.
And my lord retain its position, my lord.
Yes, as new motion.
My lord, I have an extremely urgent question. Extremely urgent. My dwelling house already been auctioned tomorrow.
What's there in the list?
19.
Very well, I'll come back at 2.
Please. No, minute. Otherwise,
Where is your other side?
I have served all the respondents.
Serving all the respondents won't do. If it is a writ petition, they have to be here.
I'm gonna know who will appear for the bank. Bank are going to auction. I have not taken any loan from bank.
permitted to mention an original
Original
site.
site.
Original site, please mention at the original site time. Today I will not be taking up because first half I couldn't take the appellate side matters. The motions are left out.
Come back tomorrow. Then.
You can't wait till tomorrow.
Yes, I'll come back.
Lord,
Original site.
Lord, before your lordship calls the list, Lord, I'm only here to disturb your lordship, Lord. 8th, Lord, is the date, Lord, for police help, Lord, for eviction. Lord, your lordship, I'm trying for leave, Lord, to file it and to move it tomorrow. The kindly seeks that the last order.
30th is the date.
30th.
কালকে দিয়ে দিন mistake কালকে বা পরশু দিন caveat is there no caveat
No, there is no caveat. Lord, leave has to be granted. I've given the certificate unless Lord department will not.
দিয়ে দিন leave to file leave to file and be listed day after tomorrow day after tomorrow 30 তারিখ আছে তো 29 তারিখ
At the matter when in the morning when the matter was placed before the Justice Court, first of all, the landed tribunal did not grant the stay. The Lordship knows this grant of any interim order is not a matter of courts, subject to satisfaction of the forum or the court. Yet the facts which have been disclosed by the landed tribunal does not impress upon the court, upon the tribunal, to grant the stay. My learned friend's point, as I understand in the morning, that the appeal is pending. And second, my lord, he was not given a hearing. And his status in the premises, unauthorized premises, is tenant. And tenant in the top floor, as usually it is seen. Building, my lord, was sanctioned G+2. Two upper floors completely unauthorized. Area of the unauthorized construction is about 6,500. Not only that, the mandatory open spaces have been, my lord, covered in extending each floor from ground to top. And my lord, therefore, my lord, when the plan was sanctioned, naturally, my lord, the foundation, of course, my lord, ought to have been made, my lord, the building to be constructed up to the 3-story building. And when the plan is placed, my lord, that there is no scope to, my lord, grant any, my lord, the other areas to be sanctioned. Because of that is the reason that was not granted. Now the tribunal has recorded the entire fact. First of all, illogically sees, my lord, sometimes the appeal is kept pending if the court, my lord, does not, my lord, grant the stay because of disposal of that, my lord, for other compliance with the other formalities, because there are certain formalities are required, and ultimately to dismiss it. This is, my lord, normally it is sometimes done. It has been infructuous. Now they have successfully, my lord, stalling, my lord, for demolition, but the persons, my lord, in occupation. Now, my lord, if they are claiming to be the tenant, how could they be tenant a portion, my lord, which was, my lord, unauthorizedly constructed in the upper floor? And that document which is annexed, I find, my lord, is of 2026. I don't know whether any other document made or, my lord, created. This honorable court, my lord, he made an attempt to convince this honorable court in earlier, my lord, in moving the writ petition, because, my lord, the violation of the naturality is one of the things which, my lord, one can move, my lord, even, my lord, bypassing the alternative remedy. There is no difficulty. But the High Court, my lord, did not intervene in the matter because of certain reasons, because they have no authority or, my lord, they have no right under the, my lord, the KMC Act to get a hearing in the matter, my lord, of demolition case, because they are not the person at whose unauthorized construction has been, my lord, made. The law says the persons to be heard, the person at whose instance construction was made. Those persons were given hearing and they participate in the proceeding. And they have they could not succeed. And they then went before after the dismissal of the petition, went before the appeal court. Appeal court, I made my categorical establishment, my lord, that they have no right. The court said that they wish to. The court has not granted them leave to approach the learned tribunal. The court has said merely that since they expressed the wish, my lord, to go before the appellate forum, therefore the court, my lord, did not pass any order on my lord, anything. Only the breather time, my lord, has been given for my lord, 1 month. That was the position. And my lord, so far as the main part, originally order was passed by my lord, Mr. Sinha. That order has been taken in a contempt proceeding. In the contempt proceeding, my lord, 2 orders has already been passed. The executive engineer then in position has in the meantime retired. And the Honorable Justice Sinha, in a contempt proceeding, has, my lord, frozen his retirement benefits until the completion of the entire execution of the demolition order. That is the order with me. And the next order which was passed by the court in the contempt proceeding, asking us, my lord, to submit the compliance report, and that order is of dated, my lord, 16th April 2026. And I have been asked, my lord, to submit the compliance report. And in earlier order, the executive engineer, the retirement benefits, who has in the meantime retired, the court directed his, my lord, entire retirement benefits.
Where is that order?
My lord, that is not there, my lord. I have got the contempt proceeding, my lord, that 2 orders, my lord, already passed by the main order, my lord. This contempt proceeding is still, my lord, pending. রাইটিং নিয়ে যাও গেছো সে সম্পাদিক কাছে বলেছে একটু প্লিজ যাও গেছো
Two things, Lord. Without going into these nitty-gritties, Lord, 5th of August is the date fixed, Lord, for hearing of the appeal. Lord, if they will not conclude, we will also conclude, Lord, by 5th of August. If the tribunal takes up the matter till 5th of August, kindly protects us for final hearing of the appeal.
I am submitting, my lord, that, but that is up to Lordship's consideration. But I am facing the contempt proceeding, number 1. Number 2, my lord, he's right. He has not, my lord, stated anything for, my lord, to say against the order of demolition, because he has no, first of all, he has no right to audience in the demolition proceeding. The law is very clear. There are a number of judgments of this honorable court, my lord, the tenants or occupiers have no right, save and except the person responsible for making another construct. Otherwise, the entire scheme will fall through. Because of the reason, one after another person will come to the court to stall the order of
the owner of the building or the person responsible for construction, he had preferred appeal against the order of demolition earlier.
No, he has not preferred an appeal because he, my lord, he had no say anything. He had nothing to say. Because admitted position, there is no, my lord, there is no scope to make any discussion about that. That the mandatory open spaces have been encroached. Upper 2 floors are unauthorized.
Where is your appeal before the tribunal, Mr. Bhattacharya?
Annexed, Lord. Lord, page 62, annexed G.
Page
62, my lord, annexed G. Regulation.
What if the building falls, Mr. Bhattacharya, in the meantime? Suppose the building falls merely because it has continued for 2 years. Is no guarantee that it will continue for another 6 months. Nobody knows.
I'm not praying for
Suppose-
6 months.
No,
Definitely. General
suppose maybe
concert.
sitting here, I stay it, and tomorrow if something happens, who will have the responsibility for that? It's very difficult, Mr. Bhattacharya. I can understand you are appearing for the petitioner, you will press for it. That is right. But think of the ground reality. This is a building which has been stated by the building engineer, or sorry, the hearing officer, that it has been found to be structurally unsafe because of superimposed load. Now, if superimposed load itself is unsafe and that has continued for 2 years, it is all the more a reason for getting it demolished now, because it has continued for 2 years. With every passing day, danger is mounting.
Corporation was not doing anything. It was only after Milord, our stay was rejected. Then Milord, they gave that notice. They
No,
were
but there is an order directing them to comply with the order of demolition. This 11 June 2026 order, which says that you file compliance reports.
subject to orders of the court. Subject to orders of the
The
court.
division bench also said that in the meantime, if you are not able to get protective orders, now you have
That's why Milord, I am before your
you have not got protective order.
Milord, that's why I am before your lordship.
Protective order is not there. Now the how do you hold that this order passed by the tribunal is bad in law? What is the reason for holding it?
Direct the tribunal to hear out it on 5th. Milord, kindly protect.
But where is the reason for me to hold that?
Milord, then Milord, let me Milord show Milord the orders one by one. This is a division bench. I suffered this. Kindly see, Milord, the appearance of the parties. Here, Milord, I appeared before the respondent number 10, who was the landlord. And Milord, tenant was at this was at the instance of a tenant. Milord, kindly see, Milord, 9. This is a division bench judgment. Paragraph 9 first.
Paragraph 9.
I suffered this. Milord, that apart, it is observed by the learned single judge, the petitioners cannot stand on a better footing than their predecessor in title, that is, the landlords in respect of the property. That is my clients. Milord, here is a case even worse than me. This is a 401. Here was 400 subsection 8. No right of hearing at all. Now, Milord, kindly see, Milord, 10, Milord, kindly see 400 subsection 8. Then, Milord, kindly see 11. That apart, it is submitted that occupants of the premises, the appellants.
I am not on your right, Mr. Bhattacharya. You also know.
Stay granted.
Tenancy right.
I'm saying
Tenancy
that
right is trumped by safety aspects. Show me that this was also a case
considered. Milord, 2 years. 408 was issued 2 years back.
Show me that it was unsafe for the merely deviation from sanction plan or not in accordance with sanction plan is one thing.
This was 400 subsection 8. Otherwise, Milord, if it was, Milord, so grave, emergent situation, 400 subsection 8 would not have been invoked.
That has to show from the
Milord, kindly see.
Section mentioning will not do.
No, the
That is
kindly see 6, para 6, para 6.
This
7.
is immediate demolition of unauthorized
Immediate
structure
demolition.
on the ground of extreme urgency, not
Exactly.
safety.
400 subsection
not-
A.
Not safety, not safety.
Safety. Yes, not kindly see. That is the language. 400 subsection 8. That is the language.
Show me that.
Emergent. So emergent that it cannot wait. That it cannot wait for a single day. Emergent situation, and that's why Mayorine
No,
Council.
emergency can arise for very many reasons. It's not safety, Mr.
It might
Bhattacharya.
fall
Not-
down at any point of time.
No. It may be because it has been constructed at such a path which is obstructing a large vehicular movement. That can be urgency. So merely because it is 400, it will not mean it is safety only.
This is not 401, 400 subsection.
Very
Kindly see the language. It's so grave, any emergency situation can come up. That's why 400 subsection. It's our case is on 400 subsection 1. Even on not, I cannot say unauthorized construction was better footing, but the case is on 400 subsection 1.
Because the reasons are not there for reasons to be recorded in writing. What was the reason which made it so urgent? There may be safety reasons. There may be
that,
other than
well,
safety.
that is the 408. No, nothing is required to be taken.
It's not
Mayorine
that
Council takes a decision unilaterally.
No. It has to be, reasons have to be recorded. What are the safety reasons? The reasons may be, urgent reasons, may be safety reasons, maybe inconvenience, maybe blockade of traffic, whatever it may be. But here in this case, it is pure safety, and it says unsafe for occupants of the buildings. This is what has been said. In the teeth of this, how can on the basis of your assertion, I say that no, it can't be done?
Kindly see, Millard, the next paragraph, Millard, paragraph 11, that it is submitted that the occupants of the premises, the appellants have locus standi to challenge such notice of demolition. Ultimately, kindly comes to paragraph 25. Para 25. Kindly see the question of locus standi in case of a writ petition under 2026 Constitution of India has been undergone a sea change in recent times and by different judgments of the Honorable Apex Court. The scope of the locus standi has been expanded largely to cover all persons who are affected in any manner by the impugned auction. Therefore, Millard, this covers also the tenants, because therefore the Honorable my learned senior friends Millard contention that the only person responsible can challenge Millard subject to correction. Millard, that is not. Even Millard, that has to be finally decided by the tribunal. But Millard, if in the meantime,
but this is before a writ court.
Because 408 is not appealable. 408 is not appealable. 401 is appealable under 403.
So when there is a right of appeal, it has to be only to the persons to whom right of appeal is granted. So in that case, this will not help you.
Then Miller, kindly see Miller paragraph
right of
35.
appeal is a restricted right. It has to be only exercised by the person in whose favor the right is granted.
Miller, possession. Who is in possession? Who is in occupation? Who is occupying?
What is the appellate right? What is the right of appeal? Under which section?
Any person.
403, 400 subsection 3.
It's 400 subsection 1 is really similar to
Subsection 3.
the matter by the primary authority to hear.
Subsection 3 to any person.
403 says Miller, any person.
That has been explained by this honorable. You can just explain that.
400 subsection 1.
400 400 subsection first provision will be heard, and without hearing him, no orders of demolition shall be passed. The person at whose instance the construction has been raised. Now, my lord, my learned friend has sought to say that regarding the appeal, that has also been explained by this honorable in number of judgments, my lord. That what, my lord, that the person at whose instance shall mean the owner, occupier, or any other person who causes the erection of any building or erection any work to be done, including alteration, if any, or does it by himself. That has been explained. Next, 400 subsection 3 any person agree by an order of the municipal commissioner,
Then by that logic, Mr. Ghosh, why was their appeal entertained? If they did not have right of
I don't-
hearing, if they did not have right of hearing, then how could they prefer
that
appeal?
point has been raised. I do not know about the because there's a long delay whether the appeal value regularly section 5 allowed or not. I do not know whether we tell them reveal that. I take it value section 5 allowed whether it is allowed or not. I don't know.
Oh, section 5 pending.
But
Section 5
section
is
5
still
has not
pending.
been allowed.
24,
But
order
it
of 24, we were never heard.
It is on a regular
You have
appeal.
the division bench judgment.
Hello?
Yes,
You
my
have
lord, I
the
have-
division bench judgment by which it has been clarified that only the persons at
Any
whom-
person, any person. I think I will give you tomorrow. You will give the division. We also,
I also have Supreme Court also. Oh, yes, which my learned senior friend will rely upon. Vijay Vishwakarma will not, that was carried to Supreme Court.
No, that has nothing. But that has been carried to Supreme Court has passed that he will go to the authority to consider.
Exactly. Feel
That is not the margin.
exactly.
That is
4.
not
Paragraph 4.
That is the margin.
4.
Because you know,
This is not simplicity or dismissal of SLP. Supreme Court has passed orders. This is not
SLP has not been admitted.
not even simplicity.
SLP has not been admitted. There is a difference of disposal of the SLP and the appeal. There is a difference. SLP has not been admitted.
Without
That is why I am arguing in a different code.
without going into this, Milord, the appeal is fixed on 5th of August.
That Vijay Vishwakarma has clarified any person everything. Now the thing is that the order which has been passed by the Supreme Court, they are going into the judgment. Judgment has not been satisfied. Judgment under appeal. You want to passed. That is for that particular person. Not in Malad. That cannot be applied to all. There is a particular case where somebody goes nowadays Supreme Court that I will go before that court and kindly judge me. That possibly sometimes is given. That this is that a law has been decided. Ratio has not been decided. Ratio has been decided much on different cases.
This doesn't help you.
No, not only Milord, for the purpose of Milord.
Is that you will have the Supreme Court has granted you an opportunity to go and make a representation for regularization.
Interim order.
Interim order was there. It was extended for a limited period.
We are at interim order stage only.
This is confined to that person only.
Safety is the only thing, Mr. Bhattacharya. If it was a usual case only of unauthorized construction elsewhere, this is something which is very dangerous.
2024 to 2026, Milord, we are in Milord almost in the end of July, Milord. The corporation did not only take steps; they have taken steps only after dismissal, Milord.
Suppose before 5th of August something happens. What will happen? Who will take responsibility?
Milord, the floor, Milord, which I, Milord, is residing, Milord, it will crumble on my clients, Milord. That will happen, Milord.
I cannot take the responsibility of that. It is better for your client to leave that.
We will be held responsible for that. Milord, for 5th, it's only, Milord, matter of another 9 days. Another 9 days.
I will leave it open to make a representation before the authorities in the same manner in which Honorable Supreme Court has done. They will consider it in the right earnest, keeping in view the fact that they have not proceeded for 2 years. If they find that yes, it can wait for another 15 days, they will wait for 15 days. I'll give this.
They will not, because they have already taken that stand.
I will clarify that. I have understood that. I will say this. Since
their office will not.
I cannot, Mr. Bhattacharya, there cannot be a judicial order in the wake of this. This has to be understood and taken care of by the authorities who are in the know of the matters. I cannot become an expert of these things.
No,
tomorrow something happens.
Not at all. So kindly appreciate one thing, Milord. Today, Milord, if it is demolished.
That is why I'm leaving it open. I'm leaving it open to them to consider. They will earnestly consider it, keeping in view the fact that it was not demolished for 2 years, and the matter is made returnable before the Honorable Single Judge on 20th of August.
Before the tribunal.
No, before the Honorable Single Judge, where contempt has been alleged against them.
We are not parties.
Yes, but they are. You will not be parties, but they are. Damocles sword is hanging on them, because if they don't comply with the order, they will face contempt. And if they comply with the order, then you are up.
Then they will say, they will say
that is why
contempt is pending. We cannot do anything. That is the whole difficulty.
What is the status? The tenant. The tenant in a particular building, he may go to the other building. There is no difficulty. That is the reasons, my lord, in my lord,
And there is
since
nothing on record
1982,
to say that the order is perverse. There is nothing on record to
since
say that this order is
Contempt court,
perverse.
with deepest of respect, my lord, cannot go beyond its order. It will contempt court, my lord, when it appears before the, my lord, learned coordinate bench, my lord, contempt court will only say that I cannot go beyond the order, you implement the
And
order.
even going legally, Mr. Bhattacharya, the order passed by the building tribunal can't be said to be perverse. It is not a perverse order.
All the
See, your section 5 is pending. He has considered your stay. He has found that it is unsafe, and he gives the reasoning. Considering the massive unauthorized construction, that is 591.83 square meter, along with infraction of multiple parameters, we are of the view that there is no prima facie case. Now, if this is the case, massive construction, unsafe, how can the High Court suddenly say, no, you stop merely because the appeal is pending? It will be setting a bad precedent, because pendency of the appeal is never a ground for granting stay. We have been arguing this. You will argue this in the next matter, that Order 41, Rule 5, you will show.
well, 6,500 square foot.
না ওইটা কি অর্ডার ছিল
This is the best that I can do. I'm keeping it open. Mr. Ghosh, please see that if you can give them some respite. Your matter is returnable before the contempt court on 20th of August. Till this date, you have not done it. If you can extend it for a few days in the meantime, I will.
These came up.
20th
I
August and before
tell
the
you, Lordship,
tribunal, it's 9th
like
of August.
this situation has been, my lord,
5th of
considered by
August, 5th of August.
1982 of our division bench. That was also my lord, followed in different courts. The court said the person
just
that is also, my lord, the persons, my lord, in occupation having no right to, my lord, say anything about the unauthorized part. They may have some time to vacate the premises.
Millard, another Millard, there is also there, Millard, all
And also there are all the other.
The content for proceedings and painting, my lord, that they can inform the
Depending, yeah,
content. I don't think my lord, the
definitely
content,
compliance with the demolition part, and also to
because my lord,
one gentleman is suffering that order
because my lord,
of retirement benefits.
no, no, retirement, my lord, because content proceeding, my lord, they can inform the court before that, my lord, that appeal is paid.
Yes, yes, my lord.
But I am for the respondents. Yeah,
কপি সার্ভিস হয়েছে সার্ভিস হয়েছে কিন্তু আমার এফিডেভিটে নেই কপি আমার কাছে একটা রয়েছে হ্যাঁ করো করো
My lord, I am for the petitioner, my lord. The petitioner is very poor and my lord labor class, my lord, and did not reside at the address, but he had electricity meter and continues pays electricity bill. But all of a sudden, due to some information derived from any source, electricity Minakha CCC assessing officer read the entire locality of the village and arbitrarily pass that they are hooking, some people are hooking, and but the petitioner also are there, but petitioner is totally innocent and there is no hooking and the service
direct
cable,
hooking from the
no, there is no evidence. Well, service cable is totally
provisional assessment,
not
final
tampered the
assessment,
service
no
cable.
appeal.
Service cable is as it is, and service cable and continuous pays electricity. Their meter is also is there, my lord.
Naturally, hooking.
Hooking is where the service cable has been tempered, but not tempered the service cable, and pays electricity bill regularly.
No, that is the bill has got no bearing with you.
Why? What is the necessity of the hooking? That is the simple in the room, and there is sufficient electricity and pays the electricity bill regularly, my lord. And petitioner did not reside at there. Petitioner is labor and go to outside the work from the village.
Well, can writ petition is maintainable?
And
Your lordship
kindly
kindly
see that-
consider me, lord.
Kindly
After
see that
issuing the
in the
final order of
locality of the
assessment, without
village,
challenging
there
the
are
same under
several
appeal.
people are affected. There are several people that, arbitrarily that they are hooking for several parts in the locality. My lord, kindly annexer, my lord, P1 that continue. I pay the bill, my lord. There is no dispute about the bill, but arbitrarily they are stated that and
কত কত টাকা করে বিল দিচ্ছে
my lord pay, my lord bill amount received 11840 no, my lord, bill is my lord current
160. Your lordship kindly see.
কবে আছে এটা my lord kindly 50 my lord, this is the earlier bill and
23rd June to 23rd July
now
has
the
already
bill
lapsed,
is,
but
my lord,
however, he has
online.
filed writ petition, your lordship can extend. Yes.
My lord,
Even final assessment also
at
not.
the time of my lord read petition, there is provisional, but after that subsequently final assessment is there, my lord.
কবে পাস করেছে এনেছেন ফাইনাল
No, no, after filing of the read petition, recent.
ডেটটা বলুন কবে করেছে জজ সাহেব আমি তো কপিও দেননি
My lord, I have take then instruction from that when the, but no, my lord, kindly leave to supplementary.
then your lordship
Let
kindly
it
pass an
as-
order because
These are my lord.
after filing the read petition after filing the read petition
Yes.
then your lordships can give liberty to file an act. A copy yes
My lord,
maybe after
same, my lord, kindly see that the petitioner is regular. Kindly annexer P2 that bill, my lord, recent bill.
yes yes
my
my lord he can still he can file
Dispose করে দিচ্ছে। My lord. Item number 9, my lord, in this case, my lord, petitioner applied for new electricity connection and paid the deposit requisite fees as per the quotation of the Minaka. My lord, in the meantime, after depositing of the quotation fee before the concerned authority, that alleged that petitioner has hooked the electricity connection, but after that provisional assessment, electric office install the electric meter to the petitioner's house. My lord, totally arbitrary manner, by God.
Final assessment. Kindly see the prayer first. Prayer is totally different. It's a not challenging not provisional bill in the year, past in the year.
My lord, yes, electricity applied on, my lord.
So what
Money
he is
received,
saying,
my lord,
that is not
annexer.
reflected in the prayer. In the prayer, they are challenging provisional assessment.
Yes, my lord. Set aside the
In 22. No, my lord, in 22. He is challenging provisional assessment. Perhaps he is, my lord, citing some other references.
This is
6, 12, 22. Can you see that
item number 10 মনে হচ্ছে দেখছি।
কিন্তু শাহজাহান তো
না 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 না, it is জুলফিকার মোল্লা, এটা 9টা 9 9 my lord connection my lord after my lord
জুলফিকার মোল্লা লর্ড
page নাম্বারটা কত my lord annexer P1 my lord, that is the quotation as per WBC is P1 my lord, kindly yes my lord, quotation fee, but and after that money receipt has been paid on 2025, that kindly that for service connection charge and new electricity connection is 10 to 2025 my lord, that thereafter no meter has been installed my lord. In subsequently my lord, all of a sudden that raid has been conducted to the entire locality of the village, and thereafter several people has been that alleged that they are hooking the electricity, and in that event my lord, the petitioner has been arbitrarily clapped in the same raid. Nothing material my lord, after that after raid my lord, after some days that meter has been installed to the petitioner's house. How new meter has been installed?
this is just
No my lord, installed after the raid, then a provisional assessment. Yes my lord, the recent raid my lord, but no installation of electric meter at the petitioner's house my lord. No, that is the nothing my new small house, and petitioner is as a labor my lord, petitioner did not reside at the house my lord, frequently come and then my lord daily day labor. My lord, I have written that
Lordship, for a moment see the prayers.
my lord, that paragraph 7 I have mentioned that after some days electric meter has been installed at a dwelling house of the petitioner. But no, but actually after paying the quotation fee my lord, there is has my lord, I have, because my lord, petitioner is not in illiterate person and not maintain the actual my lord, my lord, am I- as per instruction that as stated by the petitioner, that as petitioner stated that after that raid conducted, thereafter my lord, meter has been my lord installed. it is the district, another district, South 24 Parganas, but it is not 24 Parganas. Some technical, my lord.
No, but the affidavit is absolutely correct. Final order of assessment also shows the same thing. Name is matching.
No, prayer is also wrong, my lord. My lord, kindly, that due to inadvertence, my lord, another matter
In
has
this
been.
matter, lordship, surprisingly, the petitioner has not admitted his guilt by writing a letter. I don't know. But he is saying that I have committed this wrong. Theft has been committed by us, but I am very poor man. Let this amount be reduced.
You bring a letter of withdrawal, I'll put it on record and allow you to withdraw.
My lord,
Bring a letter of withdrawal, I'll put it on record and allow you to withdraw.
oh, my lord.
Yes, next. Not today,
My lord, day after tomorrow, my
day
lord.
after tomorrow.
Yeah. Later after. My lord.
At an event, and on proceed, my lord. He wants to withdraw, my lord. So, my lord, the settlement is bank going on that side. He wants to withdraw, my lord.
Okay.
Later.
Taken in.
In terms of 7.1 of Regulation 55 of 2013, Milord, the CSC has got no role to play. As on date, Milord, the meter is live. Now, Milord, since the building is not structurally separated, no extra demarcation is there, Milord. As on date, the CSC is not being able to proceed with the shifting.
Worship, there is a common passage, but those
The meter has been supplied in the common meter box position long back, and the meter is live. Now, Milord, due to some internal private disputes, they have approached CSC for immediate shifting. But, Milord, the building is not structurally separated. mean the same building, same address, and it is not possible, accessible, or feasible, to provide two service connections in a same premises, same address. This is our situation,
Now, my lord, after installation of the meter, I'm asking this question to myself that will the petitioner remain in dark?
Private
1 year?
respondent is there.
Who is appearing for the private respondent? Why are you not allowing the wires to be drawn?
Because my lord, one Pakistan suit has been filed.
So what?
So injunction has been granted.
So,
And my lord, no pathway, my lord, because before that, my lord, he filed a petition before the Justice Supreme Court that was withdrawn. Report filed by the police officer.
Why unnecessarily are you creating trouble?
Because my lord, no pathway, no common passage on lady. Over it going to my house. My house.
You said it is not structurally separate. How can overhead go through his house then?
It's not structurally separated, according to my instructions.
He says it is going through. It is going overhead his house. That means his house is being crossed by the building.
they have all their
within a
separate
building.
residences. They have all their separate residences, and they have the connection. Private respondent also have.
They are
the
also
connection,
having the connection in the same way.
but they are not.
The fact is that
Is it one building?
my lord.
Just a minute. Let me understand from it. It is one building.
No, not one building. Separate residence.
Then Mr. Ghosh, your instructions are not right.
According to my your lordship, kindly comes to the cost title, The address is same address that of the petitioner, same as about the private respondent.
Same village we are residing.
It is only the village,
Milord,
not the premises number.
According to my instructions,
Your
categorically
instructions
that
are not
they are
proper,
not
Mr. Ghosh.
structurally, they are not
Mr.
structurally
Ghosh, your
separated.
instructions are not proper because according to what I have understood and what I have gathered from the submissions made by both the parties, it appears that they are residing in separate structures. If that is the case, you should.
So, kindly allow me to come back after
inspection. It is not a case of one building.
Allow me to come back with after an inspection.
Conduct inspection.
My lord, I am appearing for the respondent, my lord. My lord, in this case, my lord, the petitioner has paid a sum of rupees 31,963 to provide a new electricity connection on the ground floor of the premises concerned, which belongs to his father and his uncle jointly. Now, my lord, despite receiving the payment, the CESC has not provided any electricity connection to that premises. My lord, thereafter, my lord, on 30th June, the petitioner addressed a representation to the CESC, which was acknowledged by the CESC itself, my lord. The acknowledgement your lordship would find on page 29 of my application. And the payment receipt, my lord, is on page 27.
Why have you not given?
My lord, we are ready to connection with the help of the police assistance, my lord, due to
Who is appearing for the private respondents?
Lord,
Service
this
is
is
there,
my
madam.
this is my affidavit of service.
Dekhi didi.
Private respondent raised objection, my lord.
All the private respondents have been served.
All of them, my lord.
Have you checked up?
Yes, my lord. I have also annexed the track reports.
Next, but it is very difficult to match because the postal receipts are at some other place, the track records are at some other place. You have to post the track.
My lord, I have checked
postal
myself,
receipts
my
on
lord.
the track records for facility of matching, isn't it?
Yes, my lord. My lord, I have checked them up myself.
Nobody is represented. That is the problem. Next time when you file, you post the postal receipts on the paste the postal receipts on the track record. It will be easier to. It will be time saving.
Yes, my lord.
लिखे नहीं
Lordship, petitioner has purchased the ground floor of a property, Lordship, applied for a new connection before the CSC authority. CSC authority sanctioned the connection. They went for the installation. Due to the objection, the installation.
Why, Mr. Chatterjee, why are you objecting?
As submitted by him, my lord, I have no objection to grant of electricity to him. My lord, what I raise objection is, my lord, as submitted by him, is purchased the ground floor. It has a separate entrance, separate area. My lord, at CSC authorities are entering in my premises or area where there is an existing meter board position where, my lord, I being the original owner of the house, my lord, is enjoying electricity through my meter. So, my lord, he can have his own meter being a subsequent purchaser to the ground floor which I have sold them. But it is completely separate. So, my lord, let him put his meter in his own area, my lord, I have no objection.
That also I have no objection, Lordship.
Take instructions from.
If that is also possible, we are ready to comply with the format.
I'm for WBC.
But I am for the petition. My lord, I am the successful auction purchaser. My lord, now the dues of the previous owner has been saddled on. My lord, as per the West Bengal, there is no charge is created. Nexus and whether, my lord, there is any, I am a consumer, I am a existing consumer. My lord, both in the deemed disconnection, subject to correction, my lord, this absolutely pure question of law, and after Supreme Court, my lord, which was, my lord, basically accepted the findings of the our court, when it can be a consumer and when it can be. Because once it is a deemed disconnection after 6 months, my lord, under the supply code, they cannot be considered as a consumer. I am asking for a fresh connection. They cannot, my lord, saddle the dues of the previous owner.
Yes, Mr. Bandyopadhyay.
My lord, your lordship knows, my lord, that the regulation, my lord, he has to clear the dues now, my lord. He has purchased the property.
He will not, merely because of him having purchased the property subsequently, he will not have to clear. You have to show that he has nexus, same premises, lot of things are
Well,
there.
same premises, my lord, the premises has already, my lord, an existing meter connection. And my lord, there were, my lord, more than 1.5 lakh, my lord, dues, electricity dues, my lord.
No,
I will only, my lord,
regulations he will have to show.
yes, my lord, I will only place, my lord, the sales certificate, the relevant portion of the sales certificate by which, my lord, he has purchased the property. My lord, kindly, my lord, internal, my lord, the page 23. 23.
My lord, it is better than when I show the law in this regard.
Page 23.
Page 23, my lord, internal page 5 of the, my lord, sales certificate. And your lordship sees, my lord, the paragraph 5. My lord, may I read, my lord? That the stamp duty and registration charges or any other expenses in respect of the sales certificate shall be borne by the purchasers, including all pending dues towards electricity bill, water supply, property tax, etc. So it's there in the certificate. With these terms and conditions, he has purchased the property. Now he is, my lord, taking a different route, my lord. He is different claim that, my lord, he is not in under obligation to pay.
This sale was what sale? What sale was this? Surface sale?
My lord.
Yes, Mr.
Chamal. Supreme Court judgment. My lord, I have purchased a sale and this electricity duties was not disclosed. It is not also a submission that there was whether there is a deemed disconnection or not after 6 months. It is not the assumption. So I'll presume, because I have specifically stated there is a deemed disconnection. এটা ভাই ক্যালকাটাটা দিলে সুপ্রিম কোর্টটা চাইলাম
না না দেয়নি
আনোনি এক্সট্রা কপি কপিটা আছে kindly see paragraph and I'm handicapped to the situation.
Chandrachud.
Yes, yes. 117 minute for other states there was charge, but here there has to be a subordinate legislation.
এটা বল সাইটেশনটা বল না
ও বলতে হবে
বলতে পারবি না
তারা বলছে
117,
my lord. On this issue, my lord, there has to be a subordinate legislation asking for a charge. এখানে দেখছিস অ্যাফার্ম করেছে এটা হচ্ছে জাজমেন্ট 2023-14
And what are the relevant regulations you have?
My lord,
regulation right now.
My lord, I'm sure.
My lord, regulation 46 and 46 is the relevant regulation. 13.9, my lord, the regulation.
My lord,
What was the reserve price of the property?
My lord, about 7 crores I have paid.
More than.
I have paid 7 crores.
He has purchased it more than 7 crores. Almost 7.5. है ना?
7 crores. My lord, page 22, paragraph 2. The consideration amount is mentioned.
This was the purchase price. And
Yes,
this
ma'am.
was the reserve price.
Reserve price, my lord, I have to take instruction.
I'm indicating to you why I'm asking this.
My lord.
You read section, have a copy of the regulation with you?
Yes, yes.
I also have one. You take it. I forgot.
46 beaches though. Regulation 46.
Yes, ma'am.
What was the name of that regulation which you showed?
That is 46 WBRC, dated 31st May 2020.
Service
Hey,
regulation.
service. Yes.
It was 12.9.
13.9, ma'am.
13.9.
ওই জাজমেন্ট অন্য জাজমেন্টটা ক্যালকাটা এটাও একটা কপি নিয়ে এসছিস না দুটো কপি আছে
আমাকে একটু দেওয়া
Yes.
Yes, ma'am.
Including the purchaser, new lessee, new tenant, you've got it? Nexus with the previous consumer and then including the purchaser. Got it?
Yes.
Who has benefited from the non-payment of the outstanding dues. Now this benefit, this expression benefit is an expression of many colors. Suppose because of the outstanding dues, price was lowered. That is a benefit. You can think of those lines.
Yes, ma'am, I can understand, but today, my lord, prima facie, it is not the case of the regulators that this is the reason. Kindly see the rejection.
Kindly see the rejection. I'll show the division bench which has been considered and accepted by the Honorable Supreme Court. What was the consideration? This was one of, you do not mention what under what provision you're invoking your powers, and you expect
the letter.
Page 40. Page 40. Outstanding dues pending to be cleared. This is the only line. Well, nothing has been provided. Well, this is
to provide the reasons. This can't be.
Please, your lordship knows the stereotype.
No.
You have to provide the reasons. And setting aside this, you provide him reasons.
Well, this would request, my lord. I am suffering. My lord, I have purchased. My lord, 7 crores is a huge consideration. But I am suffering. There is no reason. My lord, law does not allow them to sit on something which is illegal. My lord, it's subject to right. Today, my lord, they cannot.
There is a public element also.
My lord, public element to the. My lord, I accept that. But the price is about 1,70,000. 79,000. That is the outstanding due. Compared to 7 crores is nothing, my lord.
Yes.
My lord would kindly consider this. But at the same time, why should I be saddled? Why my lord, have they taken? My lord would have to also consider whether,
since the reasons are not there, I cannot presume what reasons.
my lord, I bow down to lordship.
Then there are two ways. Either I can call them to satisfy on affidavits, or then again by reason of Mohinder Singh Gill, this
my lord,
letter
may I put this, my lord, subject? My lord, I had fallen from my lord that there's a public element to it. I accept that. But have they taken any step? It's not a question of insolvency. This company exists, the sufficient under the loan. Have they taken any steps under law to recover that sum? It is not that the company has evaporated. The actual consumer who have evaporated, they can always pursue their remedy. 56(2) does not bar them. It's only for the disconnection part. This is not a case of insolvency. Do appreciate the existence is there. It is only the company could not pay the dues. This has been sold in the.
I see. Right now, we do not know what.
It is not the case of the regulators. It is not the case of the licensee.
Case of the licensee is that you have to pay.
Without any reasons.
Yes, that is why this needs to be set aside, because I cannot presume things in the air. Either I have to give them an opportunity.
May I see what lordships knows it better than Mohinder Singh Gill is there, my lord. Reasons cannot be supplemented. Lordships, no, by affidavit reasons cannot be supplemented.
That is why at the threshold said that no, this can't be done.
Set aside. In the meantime, I should be given connection. Whatever, my lord, subject to how many.
My lord,
do not decide.
If you say so, but then I will be harping upon the language. My lord, we have said that there is outstanding. Now he is a new he is the purchaser, he is the new incumbent, and he has applied for a fresh connection. So, my lord, outstanding dues.
What are your reasons? Why do you say that he should be paid?
No, my lord,
the basis of your demand.
Well, your lordship,
satisfy the basis of the
in
demand.
terms of the regulation, as your lordship, my lord, has gone, my lord.
That is neither here nor there. There has to be something on record to show that yes, this demand is justifiable because of these.
No, my lord, I have shown your lordship, my lord, the relevant portion of the my lord, sale certificate. He has admitted the terms and conditions of the sale. On the said terms and condition, he purchased the property. Now he can, my lord, take around.
My lord, the bank cannot decide with the bank cannot decide on the liability of electricity dues. Electricity
but it
dues
is there in the sale certificate.
Why did you not go against the actual defaulter?
No,
the person who was the consumer, why have you not?
I don't have any specific instruction on what step were taken against the erstwhile consumer.
Inform the court at least. What have you done?
My lord, your lordship.
Why have you not done it?
No, my lord, your lordship. So
come tomorrow.
Tomorrow, my lord.
Come tomorrow and inform the court why what steps have been taken against the actual consumer. Because merely because you find somebody, therefore you will foist liability on him is not the law. You have to show that yes, that person was not available because of this reason, or you have taken this step, he has become insolvent. What has happened?
Very well, man. Instead of tomorrow, my lord, let me come back day after tomorrow. If you want time, my lord. Today, now it's already, my lord.
Day after tomorrow, he wants.
Well, day after tomorrow, that matter will continue again. Just Mr. Mukherjee, my lord has fixed it only Wednesday. That's why. Thursday. Thursday, can you keep it on Thursday? And my lord, just This was the judgment. I'm giving a copy.
Yes, I think
Calcutta High Court judgment. Yes, my lord has it.
No, give me the, I don't have it. I remember.
একটাই কপি আছে জাজ সাহেবকে দিচ্ছি
আমাকে এটা দে সাইটেশনটা দে ও আচ্ছা ওইটারই কপি
হ্যাঁ
Justice Datta's judgment.
Yes, which was affirmed when, which was affirmed. Because for other states, there is specific charges there. For West Bengal, there was no provision.
12. 412.
Yes, yes. Division means Justice Banerjee was also there, Malaya's lordship then was. Because it's a very interesting point. And the last paragraph is very important. If Milo sees the last paragraph, Justice Datta has specifically stated.
ওটা খোল বইটা খোল
As stated, my lord, the provision has to be mentioned. My lord, would kindly see paragraph 87.
Paragraph
87. The last 10 lines from the bottom. What I find on perusal of the records.
Yes.
Records is a complete lack in this behalf. The appellants were not sure which provision of law was appropriate to be invoked, and hence maintained silence by not referring to it. I do not for a moment say that absence of reference to a statutory provision would invalidate an action otherwise permissible in law, but what was required by the applicants in order to invoke sub-regulation so and so was at least referred to the fact portion of the inclusive definition of consumer as contained, and say that the condition for treating the writ petitioner as a consumer under the new act stood fulfilled, and therefore it was liable to clear the dues of the Capricorn. That was not having been said, the jurisdictional fact for demanding payment of invocation of sub-regulations remained non-existent. But here also there is no provision. So if this is the law, my lord, this subject to is affirmed till Supreme Court. Here, my lord, supply code 4.64.64 as an officer of the court, it said it will prevail over all regulations. If my lord sees 4.6.4. This is of supply code under section 2.
Have it.
But this is the regulation 4.6.4.
I have it.
This is notwithstanding anything content contrary elsewhere in this regulation. So, argument of DVC was this will prevail. But there was no invocation of this provision at any point of time. Here in this case, it is better, none of the provisions have been invoked. And the officer of the licensee comes up and says that do not have to give a reason. It's more amazing or shocking, my lord, if I can say.
No. I didn't say so. Don't put any words in your mouth.
Well, that was more of sum and substance of the submission.
Okay, day after tomorrow we shall hear.
Thursday, my lord,
Thursday. Petitioner
taken or not.
Yes. Because otherwise in any case, it doesn't show any reason. You supply electricity, keep on recovering. If you find that he is entitled, you are entitled to recover, you can recover it even after supplying electricity to him.
I'm grateful.
But my lord, if we have the entitlement or the right, my lord, to recover from the purchaser,
So that you have
then my lord, the
because
regulation,
you cannot let your first right against the first person.
but the regulation says
that
regulation says
give a go by to that, and at your convenience you will grab somebody who has not consumed electricity merely because he happens to take possession of the premises subsequently. That is not right.
But my lord, the regulation says, well, before taking new connection, my lord, he has to clear the outstanding dues. The new purchaser also.
Your action also should have to be bona fide. Only reliance on regulations blindly will not do. You have to show that yes, you bona fide pursued the claim. The person became insolvent, therefore it would be written as a bad debt and should not be written as a bad debt. So let the subsequent consumer pay in terms of the. It should not be a windfall to you that you will take advantage of your laziness. That you will be lazy, you will be indolent. You will allow the consumer who has consumed to flee, and then you will grab somebody else who has subsequent.
Subject to correction, my lord, but the regulation doesn't say so, my lord. There is no condition precedent, my lord.
That regulation has to be read it. I have read in that fashion.
Very well, I will come back. I will come back. Great.
Yes, your lordship, for the petitioner, I'm led by Mr. Bikram Banerjee. He is in virtual.
My lord, I appear for the petitioner, my lord. New electricity connection. My lord, this is the second round of litigation. Payments regarding the electricity connection has already been made. I have twofold prayers. One is, my lord, police self to grant electricity connection. Private respondent is a co-sharer, my lord. He is raising objection. Now, the second part is that, my lord, on previous round of litigation, I have annexed the order. There was a theft of electricity by the private respondent. I have to pay for it to get the electricity connection because it is under the same premises. Now, my lord, what I pray, my lord, the meter which is unused of the private respondent, that should also be removed. That should also be removed from that particular place. That is also my prayer because I have to pay, because again, electricity tampering and I have to pay, and it is in the name of the private respondent, my lord. And I should get electricity connection by way of police self, my lord. I have my children, my lord, and
my lord,
I'm for one by one.
I'm for the same.
He has two grievances. One is that you are not giving him electricity supply. Another is you are not removing the meter of a person who had earlier been indulging in unauthorized use of electricity.
My lord, this is a second round of litigation, my lord. They actually, my lord, he has no grievance against me. I am ready and willing. In terms of
is the problem.
Yes.
Lordship, kindly peruse the supplementary
order passed in the earlier writ petition, my lord. There was an amicable settlement between the, my lord, the WBACTC.
My lord, what happened, my lord? There is a partition suit, my lord. Thereafter, my lord, the preliminary degree was passed. Now, my lord, this petitioner is the wife of my brother. A connection in my portion, my lord. My lord, kindly see preliminary degree is that, final degree is not there, my lord. So, my lord,
electricity connection does not stand in the way of ownership, my lord. Whatever may be the order, and we are all our co-sharers, my lord.
Portion, my lord, I have no objection. But if he is coming to my portion, but the preliminary degree is done, my lord, then I will be in problem, my lord, if the final degree is passed, my lord. That is my objection.
You will not be in problem. I will observe that merely because he is in possession of electricity is
No, and another thing, my lord, what my learned friend said, my lord, that there is a
create any equity, your special right in favor of the person.
Another thing, my lord, kindly come to page paragraph, my lord, 10 and 11, my lord. 10 and 11, it is stated that there was a electric connection, there is a theft of electricity, and thereafter, my lord, actually, my lord, what happened, my lord, they are the brothers, my lord. This brothers is using that for business purpose, my lord. That brother, my lord, whose wife is coming here, my lord, he is using that meter.
No, your lord.
Thereafter, my lord, when
my lord, it is his electric meter from where theft has been occurred, my lord, and I have to pay.
Mr. Banerjee, so far as new electricity supply is concerned, that can be directed. So far as removal of the meter of the private respondent is concerned, that becomes difficult because of the peculiar case situation here, where he claims ownership in respect of a portion. You claim you have a right to get electricity connection in the portion where you reside, but there is no hearing in you to ask.
I'm grateful, my lord, if your lordship passes this order. But my lord, I should not be held liable for theft of electricity from that particular meter.
whoever has indulged in illegal abstraction of electricity, that person will be held responsible.
But the difficult situation is, my lord, in the same premises, I have to pay for it. I have to pay for it.
Establish the appropriate forum. Why will you have to pay if you have
Otherwise, they will not give electricity connection if it is in the same premises. That was the difficulty, and that is the practical difficulty. Your lordship knows, my lord, what happens, my lord.
directing electricity connection to be given to you, overruling his objection. I will observe that electricity grant of electricity supply will not create any equity or special right in your favor. Because there is already of the partition suit. But so far as the removal of his meter is concerned, that is not a right of yours.
My lord, one thing, my lord, police help, my lord, kindly give. Otherwise, my lord.
Due to his fault.
Lord, just
there are
supplementary affidavit taken on record.
Well, there are two meters.
Lagna na
One,
chalo
one
supplementary.
industrial meter in his name, in the name of the private respondent, and the another meter connection, that is domestic meter, that is also in the name of the private respondent. No, he
in his name. That's it.
no, the industrial meter has been deemed disconnected because it was disconnected long back.
Passing any order
My
in
lord.
respect of his meter. I'm only directing you to effect supply in
Only,
his favor.
only.
That's all.
In his portion, madam, kindly direct.
No
Petitioner.
portion. Wherever he is in occupation, he'll get supply.
Yes, he is in
And that
possession.
will be the outlook of the electricity authorities where they will install the meter.
Madam, kindly direct them no equity, madam.
Yes, yes, that is goes without saying. The petitioner.
What is the supplementary affidavit taken on record? Because during the pendency, they have sent me a letter that they are unable to provide me electricity connection due to the obstruction that I have annexed, and the payment was made. The payment details.
The petitioner complains of inaction on the part of the respondent. WB.
Oh, sir. Supplementary.
কেন কি হবে?
ওই একটা চিঠি পাঠিয়েছিল মামলা হতে হতে
সেটা দাও।
এই তো দিয়ে দিয়েছি আজকে
At the place whereat the petitioner is residing.
Yes.
Full stop. The petitioner also complains that the electricity meter standing in the name of the private respondent has not been removed from the said place despite requests therefore. Full stop. Paragraph. Learned advocate appearing for the Mr. Bondopadhyay, learned advocate appearing for the WBSCTCL authorities submits that the electricity authorities are ready and willing to effect supply in favor of the petitioner, but they could not do so in view of resistance being put up by the private respondent. Full stop. Paragraph. Learned advocate appearing for the private respondent submits that a partition suit is pending between the parties and that whereat preliminary decree has been passed. Full stop. It is submitted that the petitioner is presently in occupation of the portion which falls within the share of the private respondent, and as such, the petitioner should not be granted electricity supply in such portion. Full stop. Paragraph. Petitioner installed in the name of the private respondent at such place should be removed in as much as, on an earlier occasion, the private respondent was found involved in pilferage of electricity, and the private respondent's electricity supply had to be disconnected. Full stop. It is submitted that the petitioner had to make payments for the purpose of getting such electricity supply restored. Paragraph. Third, learned advocates appearing parties or not in dispute that the petitioner of the portion whereat seeks had electricity supply. Therefore, in terms of the provisions of section 43 of the 2003 Act, the petitioner must be granted electricity supply. The WBSCBCL authority will effect supply in favor of the petitioner at the place where the petitioner is residing by installing a meter at the common meter road. Where
No,
is
no, no.
Common meter room.
common meter road.
Meter room is common.
Where is it? I don't know, my lord, whether it আছে
At the appropriate
না আমি জানি সেপারেট আছে তখন আরো 3-4টে কানেকশন আছে
Common meter room.
ওই তো বলছি yes
however, insofar as the petitioner's request for removal of the meters standing in the name of the private respondent is concerned,
unused meter, your lordship.
her prayer not allowed, in as much as, at the moment it is not clear as to whether the portion which is under occupation of the petitioner is owned by the petitioner or the private respondent. Full stop. It is also clarified that grant of electricity supply in favor of the petitioner would not create any equity or special right in favor of the petitioner. Full stop. Paragraph. If the WBSCBCL authorities face any objection or resistance at the instance of the private respondents in effecting supply in favor of the petitioner, the WBSCBCL would be entitled to approach the
Bhimpur police station, your lordship, local police station. And SP's
officer in charge,
Bhimpur.
for police assistance. Full stop. If said officer in charge is requested by the WBSCBCL for the purpose of to grant police assistance for the purpose of effective supply in favor of the provide adequate to the WBSCBCL for the purpose of execution of the job. Full stop. Costs for such police protection,
Your lordship.
police assistance could be borne by the petitioner.
Your lordship, petitioner is helpless, your lordship.
Petitioner. Full stop. How long will it take?
no 1 week
The WBSCBCL supply in favor of
I know.
Full stop.
So let's police maintain a strict vigil, your lordship. Only
177/2026 stands disposed of. There shall be no order as to cost. At the Mopore লিখে দেবেন. Service and
Before my lord rises,
deeply obliged, your lordship.
my lord, before my lord rises, my lord, my item number was 50.
Yes.
My lord, tomorrow is the date.
My lord.
That is not there, my lord. So kindly
17 I am there.
so kindly give some precedence tomorrow morning.
কালকে উপরে করে দেবেন। চলে যাচ্ছে।
My lord.
Item number 50. Yes.
Assignment কালকে ये new motion 1 এর আগে করবে। 1 এর আগে করবে।
My lord, before rising again I am mentioning before your lordship, my item number 19.
It is there for the other side. I cannot take it.
19
Item number 30.
19, you.
stand there.
But kindly take a minute, but
34 is for expeditious.
yes. But kindly, sorry.
18. Yes, sir. Yes.
Yes, my lord, kindly look at page 16. Page 16. Annexure P. The land which is going to be auctioned, the land belongs to one Sahida Loskor. One Sahida Loskor.
So he's the mortgager of the loan, my lord.
He is the mortgager of the loan. I am the petitioner herein. But what happened? I do not know who mortgaged my petition. Mortgage in the bank. I do not know. Everything has been done behind me.
Her sign is
13-2.
there, my lord, carrying the guarantee agreement, her sign is there.
What? If,
Legal separation, my
my lord, 13-2 notice has been served upon me. According to law, my lord,
Petitioner, you have created a guarantee and you do not know.
no, this is for signature.
Can get it done.
My lord, kindly look at paragraph 10. Oh, just a moment, paragraph 10, my lord. Paragraph 10 only. Just a moment.
You have your remedy before the DRT. Please go.
Then I will go to DRT, but till the auction will stop, please. The auction will say what will be done.
I think you should have gone earlier then.
No, I have gained any notice. Kindly hear me for a moment. Otherwise, Lordship will decide the matter. Kindly look at paragraph 10, my lord.
Paragraph 10.
Paragraph 10. The petitioner that all the above activities have been done behind my back. The petitioner has no knowledge about the above loan.
Mr. Counsel, it is a question of fact. You have executed a document. You are a guarantor to the loan. You don't know the problem.
My lord, this is the false document I am telling you.
Well, if it is a false document, it cannot be decided by a writ court.
I know it. But if this is a complete violation or not a violation of principle of natural justice, no notice. But wait, kindly look at the first section 2, section 2F for the moment. Mortgagor itself a borrower. Mortgagor itself a borrower. Then what?
All of this you can argue before DRT. You go and file.
I know, my lord, I know very well. But when the principles of violation of natural justice, then the deed will lie. Then the deed will. Yes, no notice has been given to me 13-2, my lord. No notice has been given to me 13-2. My son has done behind my back. Everything is done. Kindly look at my lord. Please kindly look at my lord. Section 2F. Section 2F. Section 2F, my lord. Why has the book? Kindly look at the section 2F for a moment. Whether I am entitled to get the section 13-2 or not, but that is not served to me.
Yes, not a problem.
That
you have served section.
Have served. They have annexed the notice. They have not annexed the track record. We have served. Now, their case is that they are not the borrower, not the guarantor.
Yes.
They have executed the guarantee agreement.
No, my lord.
13-2, 13-4. All
My
of
lord,
the
kindly,
notices he has been.
my lord, kindly stop the action for 7 days. I will take the remedy.
Not at all. Likun. This writ petition assails an auction process